leave to file certificate without certificate copy, my lord.
Yes.
Plus, my lord, I would be seeking, my lord, your lordship's leave, my lord, to move an urgent appeal, my lord, before your lordship today, my lord, at any time. My lord, this involves the personal liberty of a person. My lord, both of these petitioners, my lord, they belong to the party in opposition. Now, my lord, two frivolous cases came about to be registered. My lord, as far as the main accused person goes, who is also the head, my lord, of the party in opposition, my lord, against him, the protection order has been given of no coercive measures in respect to the same two cases. My lord, the main allegations were against him only. My lord, law of parity, my lord, mandates that I should be, my lord, getting the same order. However, my lord, the learned single judge, my lord, without, my lord, considering the fact that the law of parity, my lord, has refused our interim order, whereby, my lord, the same single bench was pleased to grant no coercive measures to the main accused person.
There should have been some reasons assigned for.
My lord, the reason, my lord, which was assigned was this, that the malafide part, my lord, which was considered as far as the main accused person goes, for no coercive measures, my lord, that was the ground on which no coercive measure was granted.
First case.
Brigade, my lord.
You will have to, who Advocate General will appear?
My lord, Mr. Amitesh Banerjee would be appearing, my lord. He's for the, my lord.
You can inform them.
Brigade,
because we have granted leave.
Brigade.
And it will be listed first case tomorrow.
Brigade.
My lord, I'm saying it will be tomorrow for application for stay. Entire building electric connection 5 has been disconnected.
Please.
My lord, let it be tomorrow. My lord, tomorrow.
May I have a lordship to mention an appeal from an order passed in a contempt application any day as your lordship pleases, may it be listed. It was filed in November 14th. Any day it will.
It can come after vacation.
It can. It can come after the vacation.
No, it can.
Any day lordship specifies so that it can appeal.
And this is a regular appeal against order passed.
Yes, regular.
Recently, Supreme Court has passed an order. You remember, I think day before yesterday. When appeal is maintainable against an order passed in a contempt application. I read it in that bar and bench or live law.
But I'll have to check that.
Considering Bidnapur Cooperative.
Yes, but I'll have to check that. When this is not an order passed by issuance of a rule. It was after rule was issued. Thereafter, after adjudication.
Oh, it is an order of
yes,
punishment.
Yes, but after disposing of the contempt application.
Oh,
so that is why
19, section 19 appeal.
Section 19 appeal. But I'm so grateful. Yes.
Immediately.
May I have my lord's kind leave to mention a matter, my lord?
One minute, Mr. Das. Because I don't think so. We have got determination for a 19 appeal.
Section 19 appeal, perhaps there is another determination.
I'm so sorry, but I'll check it up. I'll check it.
Notification. Appeal under section 19(1)(a).
Yes.
It will go before the division bench of Justice Joy Malak.
I shall mention. I'm so grateful.
Number 28.
I apologize for this inconvenience.
Yes,
please. To mentioning for inclusion.
May I have my lord's kind?
Yes, Mr. Das.
My lord, an order was passed by Justice Sabyasachi Bhattacharya releasing a matter on personal ground. My lord, the matter has still not been assigned. There is an urgent application that is to be moved.
Mr. Das, I was not physically available. Yesterday, about 55 files I have cleared. You just check up with the officer on special duty, OSD. If it has not been done, it will be done today. Up to yesterday,
my lord,
I have cleared all the
much
files.
obliged. Much obliged, my lord.
Your lordship's permission, may be permitted to granted leave to file a PIL relating to violation of the Forest Rights Act in the Great Nicobar Islands, my lord. The expression of interest for felling of trees is there, and there have been.
Will it not come? Oh, PIL
there is
come before circuit.
No, there is
circuit bench. You can move.
There is no sitting right now. I'm given to understand that only in this next month, my lord.
Because it will be better if you move the circuit bench.
I understand, my lord, but there is because the entire FRA violations, I won't take much time of your lordships because there's if the EOI for felling of trees.
One thing is, you will also have a chance of appearing before the circuit bench.
My lord.
And it's a very picturesque place in Port Blair. That is one big advantage. And it is nearer to Chennai. The flights are cheaper than Calcutta Port Blair. Chennai Port Blair flights are cheaper. Thirdly, more importantly, the respondents
Yes.
will be within the jurisdiction of the circuit bench.
My lord, this is the violation of the Forest Rights Act where the union, both the MOEF and the Ministry of Tribal Affairs, in fact, we'll also can appear before your lordships on virtual mode because there's considerable urgency because the entire project is being steamrolled, saying that these compliances have been done when everything has been done within a matter of 3 or 4 weeks without getting any consent, even the constitution of the
All right.
committees.
You file it.
I'll,
Let us see.
may I, on Thursday, my lord?
Yes.
Deeply obliged, my lord.
Your Lordship, I am mentioning a matter. This matter was mentioned before the bench in charge yesterday. But today I am again mentioning this matter for hearing before
Application.
for application before Friday.
What is the urgency?
Friday is contempt application.
This is a contempt application.
Contempt application is pending before the learned single bench.
Contempt application is pending before the learned single bench,
Fixed on Friday.
which is fixed on Friday.
This is the group 9 matter.
Yes.
Yes.
So it will come on Thursday. Tomorrow. Tomorrow it will come. Yes.
My lord, illegal construction is going on by changing the nature and character of the land.
Throughout the state.
My lord,
Throughout the state it's going on.
my lord, this is a PIL matter. My lord, may takes up the matter. We have already filed the exception to the report they have filed.
What was the last hearing date?
My lord, matter was listed on 12th of this month.
It is running the list even now.
It's
You want
running.
upgradation.
My lord,
Please
may
write.
please.
You give the letter, let us see if we can do it.
Appellate site, daily list, serial number 1.
Yes, sir. What is this, sir?
So this pertains to, my lord, the communal riots which took place, my lord, in and around Calcutta, my lord, on the eve of Deepavali. The state had filed their report. We have also filed our exception to it, my lord. My lord, the matter needs to be heard out, my lord.
But kindly keep it sometimes after the vacation. I don't think.
But I think there is some observation. No. Oh, riotous situation. And Learned Advocate General raised a issue regarding maintainability.
Yes.
Yes.
Now, thereafter, my lord, they have filed their reports, my lord. We have also introduced our exception, my lord. It now, my lord, requires to be heard out. My lord.
Yesterday, Supreme Court has passed an order saying that even in a non-schedule offense,
Yes. NIA.
NIA can.
Well, I need to look into that judgment. Well, I read it in the newspaper.
Because right through we were given to, we followed the dictum that if it's a schedule offense, automatically the case file has to be handed over. Now the Honorable Supreme Court says even in a
Possibly, my lord, it is on the power, my lord, of the central government as available under section 6, subsection 5.
I think that case arose under the Narcotic and Psychotropic Substances Act. You please check up the
Possibly, my lord, anything which tends to, my lord, impact the security or sovereignty, my lord. That aspect also, my lord, has to be, my lord, looked into, my lord.
like cross-border transaction.
Cross-border, anything international, my lord, if we look at the chain of events, my lord. So, maybe, my lord, I'll just check that out.
Now, exception has been filed.
Yes,
Everything
we
is
have
over.
filed our exception, my lord. It needs to be heard out, my lord.
We have heard the learned advocates for the parties.
You want the judge?
The pleadings are complete and it is requested to the learned advocate general that the matter be fixed after Christmas vacation so that the matter can be heard finally. List the matter under the same caption for purpose of fixing the date for hearing on 9th January. On that day, we will see how the situation is.
Well, before your lordships switch over to the next matter, my lord, with the leave of Justice Bhattacharya, my lord, all of us, my lord, the members of the bar, my lord, express our condolences. My lord.
Thank you.
The lordships.
Irrespective of the age, my lord, a father is
He is
always
always a
That is
father.
true.
like an umbrella.
Thank you.
Serial number 2.
কি নাম রে মামাটা? Two.
Sheru Shankar.
As far as this matter is concerned, Millard, I am of
Ensure all public transport so and so.
My lord, your lordship
no
may
copy has
recollect.
been served on the Union of India or the railways who are parties responded. But I've gathered, Millard.
But earlier we had dealt with one matter.
Yes,
My lord,
but
we have annexed that
page
judgment to
57.
page 57.
Where they were supposed to
Yes.
block the train
Right,
going
right,
towards.
This is that
Jharkhand.
one. This is
Yes,
that
it is that matter, but it has become an annual event now.
62 observation.
And who will appear for that organization?
My lord, I believe, my lord, we have served upon.
Has not been made a party. There are certain private respondents.
It's not a registered organization.
And
The organization is not registered, so we could not have made organization a party.
But then, if you do that, then the general public will be put to.
What has been stated, my lord, there was a letter, my lord, issued on the 30th of October by this particular organization. They are, my lord, essentially an organization, my lord, advancing, my lord, to all the
The organization has withdrawn their support from this.
my lord, they
They
had
have been
written, my lord, the Honorable Chief Minister, on the 30th December,
Ram Zira
October
office.
2024, asking for a speedy resolution. And it concludes, my lord, by saying that immediately considering the above demands, I request to take action to implement them by 15th of December
But then,
2024.
Mr. Bhattacharya, even on last occasion, we had pointed out that this is beyond the scope of this state government. To include a particular community under a particular reservation category or reserved category.
Pertaining to that, my lord, kindly, my lord, the demands were, my lord, immediately set up a Santhali Education Board for Santhali Medium Education. Formation of monitoring committee for Santhali. Formation of the monitoring committee for Santhali Medium Education in this district. Blocks of Poschimonchor areas under the state of West Bengal should include Santhali language. My lord, possibly, my lord, what has been represented, my lord, by the petitioner, my lord, these are the representations, my lord. I have, my lord, made photocopies also, my lord.
My lord, we would pray for a copy to be served on us.
And
The
what-
railways
my
have
lord,
been made parties, my lord. We do not know what the matter is
Well,
all
we have
about.
served upon the railways.
No,
Well,
it
we
has
have the affidavit of service with us.
Lord,
Well,
the
another
have
demand,
been
but there are
told that
several demands as pointed out by
yesterday
Mr.
they were
Bhattacharya, including my lord, this about
that nobody is represented.
their resistance against the Uniform Civil Code too.
How can somebody block a highway?
Yes.
See, day in and day out, so many processions are being held in Kolkata. And repeatedly petitions are filed, government denies permission, that's being challenged. And ultimately, even if the court decides to grant permission, it is the least inconvenience to the general public. And you block National Highway 6, this is against public interest.
Clearly considering the above demands, I request you to take action to implement them by the 15th of December 2024. Otherwise, we will be forced to embark on an indefinite mass movement from 2012.
But rail and road roko.
Both.
Rail and road roko.
You
Copy दिया था, तो copy टा दिया.
no, we don't know.
किभाবে
No, we do not know what is the stage of consideration of the representation.
67, my lord, it is their sole criteria, my lord, on the basis where they file this public interest litigation.
Yes.
My lord, just clarify that the letters are before your lordship, my lord.
Well, your lordships have given directions at paragraph 14 to 16 of the earlier order.
14 to 16 pertain to some different community. It's not pertain to this.
No, the issue is the same.
It's identical.
Whether you can block the national highways.
Last
The
time it
railways.
was Purulia and Paschim Mednipur. This time it is Paschim Mednipur.
Asking this question to myself, is it a case as is being introduced by the petitioner and is being supported by the state, my lord? That, my lord, it is a case where, my lord, it is the same.
The lordship may recollect, Mr. Bhattacharya is making these submissions. After your lordship passed this order, my lord, these community went on a rampage in our city. Lordship may recollect, this is a matter of public record.
No. So far as this incident, which came up in the earlier petition,
Right.
I think somebody mentioned that they withdrew the.
My lord, they
Later.
withdrew later subsequent to your lordship's direction.
They withdrew.
Subsequent to your lordship's direction, what happened thereafter? Within a month, my lord, they came to Calcutta. Your lordship may recollect. And my lord, they stormed into Esplanade area
And my lord, the passerbys were beaten up. So we cannot presume that this will be a non-violent movement.
What is the stand of the government on their demands or?
First is, so far as the demands are concerned, what is to be negotiated is something different. But for that, if your lordships may kindly have a look at page number 67, they are this is in Bengali vernacular. The leaflet says that for an indefinite period they are going for the national highway blockade.
Extra copy
This cannot be permitted. But
if they have got some genuine grievance, that you may consider.
No, that is always done, in a different forum, as your lordships know. But the immediate the actions or the demonstration that they intend to take.
First demand appears to be to cancel fake ST certificates. That I think.
But that is there is a process on to that.
And several writ petitions were also filed by those certificate holders. We have dismissed those writ petitions. Then request implementation of the 5th schedule. What is the 5th schedule act?
But let us see demand 4, my lord.
And demand 2 is there, that is Uniform Civil Code. Demand 1.
No, I am in the letter.
Oh, achha.
So later we don't have it.
Later we don't have. Oh, achha.
That we don't have. We have got only this.
Yes, this one only.
This is to the project manager. This is to the project manager, National Highways Authority.
না ফিফথ শিডিউলটা কোথায় লিখেছে এখানে কিন্তু এটা নেই ফিফথ শিডিউল এখানে নেই
going by the leaflet Miller
immediately set up Santali Educational Board for Santali medium education. That's a policy decision to be taken.
Right.
We cannot ask them to decide in a particular fashion.
Right.
Then formation of the monitoring committee for Santali medium education, that is also relatable to demand number 1. 3. Blocks of so-and-so should include Santali language as regional language for Gramin Dak Sevak, central government. The laws of the 5th schedule of the Indian Constitution implement immediately, identifying the tribal area. Commission consists of retired judge High Court to investigate fake ST certificate. Take strong steps from your end to repeal the anti-tribal Uniform Civil Code 20. None of this we can issue a direction.
4 and 6, my lord. Let us give 4 and 6, my lord. The rest are, my lord, within the purview of, my lord, within the domain of the state government, my lord.
Sir, 1 and 2 constitutes, 1 and 2 to set up an educational board and medium of education is essentially a policy matter.
Yes.
So there are several parameters involved. Certain states have got a 3-language formula or policy. Certain have got 2. Certain have also got 4, depending upon the demographics. Because this has occurred because after the state reorganization. So essentially, what is the language? You can invite them for a discussion.
But that can be done, but the immediate need is to stop this.
That we will not permit.
Yes.
What they say is, my lord, that we will, my lord, embark on an indefinite mass movement. My lord, may clarify, my lord, that mass movement will not be
by this public interest litigation.
Complete blockage of, my lord, the
not complete any blockade.
They should not come on the national highway.
The petitioner
as far as they're coming on the national highway or not, I don't have any instructions.
Has highlighted a very important
Bangla.
Concerning the proposed agitation of an organization called as Bharat Jak Maji Sagana Mahal, traditional social institution, Medinipur Zilla, within bracket undivided. The said organization appears to be an unregistered organization, and therefore the petitioner has impleaded the private respondents 15 to 25 who represents the organization, of whom The 15th respondent is the Dilla Pargana of the undivided Medinipur Zilla, as has been mentioned in the letter pad of Bharat Jak Maji Pragan Mahal. The grievance of the said organization appears to be with regard to setting up of a Santali medium education board and related issues. The learned advocate representing the private respondents has placed before us a copy of the representation given to the Government of West Bengal, addressed to the Honorable Chief Minister dated 30/10/2024, wherein the following six demands have been placed. Sir, here it's here. 1 to 6. The representation also states that the government should take necessary action to implement the demands by 15th of December 2024. Otherwise, there is a threat stating that they will be forced to embark on an indefinite mass movement from 2012-2024 involving thousands of tribal people. So far as the demands which have been set out above, we find none of the demands can be sought to be enforced by issuance of a writ of mandamus. As essentially they deal with policy matters as well as classification of a particular community as a reserved category under the Constitution of India. Copy of another representation by the same organization addressed to the project manager, National Highways Authority of India, Paschim Medinipur, dated 26/11/2024, has been placed before us, from which it is seen that the organization has taken an unanimous decision to take National Highway 6 blockage program, and they propose to block the National Highway indefinitely from 6 a.m. on 20/12/2024. The question would be as to whether the organization and the organizers, some of whom have been implemented as private respondent in this writ petition, can do so as mentioned in their representation dated 30/10/2024 and 26/11/2024. The answer to the said question should be a definite no. We had an occasion to deal with a similar issue, more or less a similar issue, involving a particular community called Kudmi, K-U-D-M-I, Kudmi community, where they planned an agitation on 20th of September 2023, proposing to indefinitely block the national highways, the railways, etc., thereby affecting train services and movement of other modes of transport. This was objected to, and a public interest petition was filed by the Purulia Chamber of Trade and Industry in WPAP 503 of 2023. The court considered the entire matter, as well as the decisions of the Honorable Supreme Court in so-and-so, 2020, 10 CC 439, page 61. As well as the decision of the High Court of Guwahati in so-and-so, 2019, 5 Guwahati Law Report 642, page 62, para 8. And it was held that the Samaj, which had proposed the blockage of the national highways and the railway tracks, cannot hold innocent citizens to ransom by seeking to hold an indefinite protest by blocking railways and roadways. Therefore, having come to such a conclusion, certain directions were required to be issued, and the same were issued by order dated 19 September 2023, and it will be useful to refer to the operative portion of the said order. These quotes from paras 14.
14 and 18 can not relate to
13 to 19. The above decision had attained finality, and we are informed by the learned Advocate General that after the order was passed, the said Samaj had withdrawn the agitation. But however, the agitation took a different turn after a month, where without any advance intimation or permission, the Samaj went on a rampage in the city of Calcutta, causing great inconvenience to the public, and it is also alleged that several persons were also injured. As mentioned above, the demands are essentially policy matters and matters involving inclusion of a community as a reserved category in the Constitution of India. The court cannot issue any direction to the government to act in a particular manner or to formulate a policy in a particular manner. So far as the demand number 5 is concerned, the organization seeks for a commission to be established consisting of a retired judge of the High Court to investigate and reject the fake ST community certificates immediately. The learned Advocate General submitted that action has been taken for thorough verification of all ST certificates which have been issued in the past, and wherever it is found that the certificates are fake, immediate action has been taken to cancel those certificates. In fact, a public interest petition is also pending before this court, wherein appropriate directions have been given and periodic reports have been filed, which shows that there is action being taken to scrutinize the ST certificates which have been issued earlier and to cancel those certificates if the candidates do not belong to to an ST community and had obtained such certificates in a fraudulent manner. Thus, considering all these aspects, we are of the clear view that the said organization, namely Bharat Jagat Mahaji Pragal Maha, of which the 15th respondent is the Jilla Pragan of the undivided Medinipur Zilla, cannot organize any blockage of highways or the railway lines as proposed and mentioned in their representation dated 30/10/2024 and 26/11/2024. Therefore, there will be order of perpetual injunction restraining the organization's members individually and collectively from conducting any agitation, be it for a day or indefinite, blocking the national highways or the railways, which they have proposed to do from 6 a.m. on 20/12/2024. In the event this order is being violated, the respondent state is at liberty to take appropriate legal action against those persons who defy or violate this direction. So far as the representation given to the Honorable Chief Minister of the Government of West Bengal, dated 30/10/2024, it is for the government to consider the representation, since we are of the clear view that the demands set out in the representation cannot be implemented or directed to be implemented by issuance of a writ of mandamus. Therefore, full stop. The issue since the issue involves a large section of public, it would be well advised, it would be advisable for the government to take into consideration the representation and, if feasible, to call for a discussion with the members of the said organization so that the issue can be sorted out. With the above direction, that question is
Grateful, intelligence, that passing of this order, will not prevent them, from demonstrating peacefully, without blocking the road.
no, that you take permission. You take permission.
Yes, that will be upon permission.
That is already there. They have got.
Kindly clarify that, otherwise, it will be presumed that,
Next.
Great.
I'm
Grateful, my lord.
Serial number 3.
But serial number 3, my lord, I am for the appellant, my lord.
What is this?
What happened, my lord, yesterday I have taken the leave due to urgency. Now, my lord, a writ application has been filed suppressing the fact a civil suit is pending. A writ application for police inaction has been filed. If your lordship see the stay application, your lordship will find the prayer in the writ petition. If your lordship kindly straightway come to the prayer in the writ petition at page 26, that some complaint has been lodged before the police authorities and police authorities are not taking any steps. Now, in that said writ application, it has been totally suppressed that the writ petitioner, one of the co-sharer, filed a suit for declaration and injunction that he is the owner of the property. And in that suit, my lord,
No, that the learned judge in paragraph 2 of the order, impugned order,
my lord,
has said, as advocate appearing for the private respondent submit, earlier writ petitioner opposed so-and-so, the 2 writ petition numbers have been given. Further submits that they may be organizing a fair, but with the consent of the land in the land.
That is the issue. Why? Because my lord, the present writ petitioner, my lord, himself filed as a co-owner, himself filed a civil suit. In that suit, we entered appendix, filed written statement. In the written statement, we have categorically mentioned that we are enjoying the property for more than 40 and 50 years, and there is a mela in Paschim Medinipur in the name of your lordship knows the Khudiram Basu, that Khudiram mela, which is to be performed for only 7 days. That is continuing since more than, my lord, 18 years. Now, my lord, what happened, my lord? Now, my lord, ultimately that civil suit, they did not appear. Civil suit has been dismissed for default. They filed an application, order 9, rule 9 for restoration. Everything has been suppressed in the writ petition. Now, my lord, suppressing the fact, they moved before this court as if they lodged a complaint before the police authority without stating the fact that their title is in dispute. They himself filed a suit.
And who's the appellant?
Now, appellant is, my lord, who are performing the mela, my lord, who are the neighbors of the.
All right.
Now, my lord,
who is the actual registered owner of the property?
According to them, they purchased the property 2 plot, but my lord, they filed a civil suit that declare that deed by which they have purchased, that is a valid deed, and a declaration and restraining us, my lord, from entering that property. That suit has been dismissed for default.
But was there any interim injunction?
Interim order initially was part, but in status quo, in view of, my lord, dismissal, everything goes. Now, my lord, they have filed order 9, rule 9, my lord, for restoration. That is pending. Next date is in January 2023. Everything has been suppressed. Now, my lord, what happened, my lord? Kindly see once, my lord, the earlier occasion, my lord, the earlier time, my lord, if your lordship see once, my lord, my application at page 46, the permission has been granted, my lord, for 2023. Kindly see page 46. This has been granted by BDO, OC, Pradhan, and everyone. Now, this year, my lord, the mela will be started only for 8 days, my lord, from 25th, my lord, for 25th December to 1st January. After 2nd January, everything will be dismantled. Now, my lord,
when this permission was granted,
this was
2023.
Now, this year, my lord, kindly see page 71. Page 71. My lord, Pradhan and Shahapati has already granted the permission. When the matter is pending for consideration before the officer in charge, they move before this court. And this honorable court, and kindly.
No, did they challenge this permission?
Absolutely not. Kindly see the prayer of the writ petition, and everything has been suppressed, my lord. Kindly see prayer at page 26 of the stay application. The prayer is simply stated, and the, my lord, first day motion stage without giving any direction for exchange of affidavit, my lord, this order was passed, restraining us not to perform the mela without taking consent of the petitioner. My lord, the petitioner will never grant the consent, my lord, because civil suit is still pending. Kindly see the
Yes,
pre
sir.
and I have only cited by one judgment, but there is a
That we'll come
I'm
back
sorry,
to.
I'm
We'll-
sorry.
Malad kindly comes to Malad the impugned order second page. On the third paragraph, Malad in view of the contention advanced by the private respondent, I direct that without the permission of the present petitioner, provided that the land belongs to the, provided that land belongs to the petitioner, no fair could be conducted the land of the petitioner. So Malad this appeal suggests Malad the land belongs to petitioner. Otherwise, Malad they did not Malad prefer this appeal. Malad we purchased the land by registered instrument. In the revenue record of rights, our name has been recorded in the revenue record of rights. Malad the civil suit, since they are Malad the creating disturbance in our possession, we filed a suit for declaration and injunction. Injunction order was passed. Unfortunately, due to non-appearance of the learned advocate, matter dismissed for default. Order 9, Rule 9, the file. Now, in the instant writ petition, the issue was that we planted some trees on our royalty land. They uprooted the plant, and they says they will conduct the fair. If my lord kindly comes to they have in their application, they have annexed the plaint and the written statement also. In the written statement, they are the statement, their admission that we have a share on the subject land at base. I am kindly comes to page 66. Although this is Bengali document, I am Justice Bhattacharya is there, I am reading this. Kindly comes to paragraph the 24. অধীন বিবাদীগণ নিবেদন এই যে নালিশি সম্পত্তিতে সময়ের মধ্যে সাজ থাকে অ্যাডবেস্ট বাদীগণের অংশের সম্পত্তিতে সাব্যস্ত হইতে পারে so they are not disputing that I have no right.
How the fair can be stopped? It is performing last month 20 years.
Learned friend, so any
You are the
document.
defendant in the suit.
Absolutely.
So you have submitted before the learned single judge that the civil suit was pending.
No, civil suit dismissed. It is wrong submission.
So you have submitted. Kindly come to the
I've
impugned
seen
order.
that order. I've seen.
You appeared before the learned single judge.
My learned friend appeared.
So,
Maybe.
so he submitted this fact. He has submitted a wrong fact.
But kindly see the scope of the writ petition.
Say, Mr. Mukherjee, this is a wrong recording.
I know, my I have to apply that. Now,
Apart from that,
my
what is your right over the property?
my right, my kindly see, my
You may be conducting Mela for 30 years, 50 years.
may I?
Does it
My-
give you a right on the property?
But that is subject to, that is not the subject matter of the writ petition. That is the suit. Now, my if I
Assuming he withdraws the civil suit. Now
Ma-
the suit is dismissed. It is no longer pending.
No.
But he is a registered owner.
no, my he is in cloud. That's why he filed the suit declaration.
Who are you?
But I am my
No,
kindly
if
see.
you are a co-sharer,
I am one part kosher. I am adverse position. My leadership knows if I, but that has to be decided in the suit. Now, for the timing,
Mr.
kindly.
Mukherjee, you obtained permission. They were hard while the permission was granted.
But whether this was the subject matter of challenge in the writ
So
court.
now order 9, rule 9 is pending. Thrash it out there.
But kindly visualize my page 70. But kindly visualize page 72. But kindly visualize page 72 once.
No. We have heard
But
it.
may I just once?
We have heard.
But
Appellate.
only for 7 days. Only for 7 days. Kindly appoint a special officer.
Appellate.
But only for 7 days. It is a matter.
Agree.
It is a sentimental of the entire area, my lord. My
Sorry,
people,
sir,
my lord.
sorry.
But
You
kindly,
choose a different venue.
Mr. Mukherjee, then you could have sought for permission from them. If you say so, we can allow that. With the permission that has been provided, you obtain their
for
permission.
this, when the suit is pending, your lordship believes
You
they will-
started by saying there was a suppression. When
A
you are
suppression-
represented, your advocate submitted that is pending.
No, but he said that he has not submitted the same. I know the procedure.
then-
he has
then-
to go before that court.
Then we
Now-
are allowing you to
only-
withdraw. approach that court.
Only caliber 7 days, kindly see once, page 76, kindly see once. Page 7, Honorable Chief Justice, kindly see page 76, once. Everything has been completed, ground, everything. But whatever may be the condition, kindly impose, let a joint special.
You have taken that decision. You have taken the decision. You have
permission
behind the back of the.
But this is going from last 18 years. But let them one of the let their presence may be conducted. Let their but for 7 days.
This way, the learned judge is given liberty to take their permission.
But they will never.
You are a.
But they will.
You are nobody in the land.
But one of the. I am the owner. Kindly see the plot of land where the permission has been granted. Kindly see once.
Mr. Mukherjee, we cannot decide on the
only one thing.
Yes,
but these plots not belong to them. But Justice Bhattacharya,
private respondents.
Sorry, sir. Sorry.
The private respondents in the writ petition.
We will approach. They will never grant the permission.
This intra-court appeal challenging the order dated December 12, 2024, passed by a learned single judge in WPA 29302 of 2024. By the said order, the police authorities were directed to keep a strict vigil over the issue and to see that no untoward incident occurs because of the existing inimical relationship between the writ petitioner and the private respondent / the appellant's hearing. Mr. Mukherjee, learned senior advocate, Mr. Mukherjee, learned advocate, appearing for the appellants, submits that the writ petitioners have suppressed the fact that the civil suit was that there was a civil suit between the parties which has been dismissed. Mr. Mukherjee further submits that the appellants herein are performing the fare for last how many years, Mr. Mukherjee?
This year will be the 15 years.
For the last 15 years, and in view thereof, the appellant should be permitted to conduct the fare for this year also. Mr. Mukherjee places reliance upon the draws the attention of the court to the permission granted by the Paschim Medinipur Jila Parishad in favor of the appellant's hearing for conducting the Mela from 25th of December 2024 to 1st of January 2025. First up.
But these plots are not the subject matter of suit.
It is not in dispute
these
that
plots are not subject matter. Kindly see once the schedule of the plaintiff.
These
plots are not, my lord. Kindly see once.
We are not interfering with the permission. If you have permission, you cannot.
But kindly clarify that same, my lord. Kindly see the schedule.
Not in dispute that the civil suit has been dismissed for default and an application for restoration of the said suit under the provisions of Order 9, Rule 9 of the Code of Civil Procedure being Miss case number such and such is pending. First up, the question would be as to whether the appellants herein have a right to conduct a fare in respect of the plots in question, which has been, for which permission has been granted by the Paschim Medinipur Jila Parishad. First up, the private parties are claiming title in respect of the plots. First up, such a dispute cannot be decided by this court in an intra-court appeal against an order passed in a writ petition alleging inaction on the part of the police authorities.
That has been done. I have restrained.
This court further finds that the learned single judge directed the appellants herein to approach the writ petitioners for permission for holding the fair. First up, in view thereof, we find no reason to interfere with the order.
Kindly modify that part. He will never grant permission. he will never grant permission, my lord.
He
And my lord, when your lordship is found that my lord, this is a my lord, intercourt appeal, my kindly my civil dispute.
35 of 2022.
My if we approach, kindly clarify.
This case number
35 of 2022.
pending before
My civil judge,
Pending before
civil judge junior division Ghatal. My only one thing, if we made application, my lord, let them my lord, say yes or no, my lord, anything. Because my lord, if we the landed honorable single judge says we will approach before them.
That is there. That is
No,
there.
but last part is not there. If we approach, if they refuse or they have to give some reply.
It is intact. See, your challenge to the order passed by the single bench
My single
has
bench,
been rejected. Single bench has said
no, a read petition allowed. Read petition allowed, my lord.
that is true. In
But that is not the prayer. That is not the prayer in the.
So we will direct a private party in a writ petition that
Exactly, that has
consider
been done.
and pass an order.
That has been exactly done.
next.
That has been exactly
Yeah,
done.
Real number 4.
Grateful.
Grateful, my lord.
I am for the. My deepest condolences to Honorable Chief Justice. Lordships, we express deepest condolence.
Thank you.
My lord, an assessment was made, my lord. The last date was fixed on 19th January, my lord. But my lord, petitioner could not appear, my lord. The consultant appeared before the authority. He said that next date will be communicated. But it was not communicated, and my lord, thereafter the draft assessment order was passed. And my lord, that draft assessment order was communicated on 24th. And my lord, the law requires that the 7 days time is required to be allowed for filing the rebuttal against the draft observation made in the draft assessment order. My lord, since 7 days time was not allowed and the order was passed before expiry of the 7 days, my lord, we filed an appeal. My lord, the law requires that 15% of the tax in dispute is not required in case the draft assessment, the time to file the rebuttal against the draft assessment order, 7 days time is not allowed. Well, that appeal was rejected ex parte because we could not appear, my lord. Thereafter, my lord, we challenged this application, this order before the honorable tribunal. My lord, the tribunal, my lord, since the application for condonation of delay was not filed, tribunal granted us liberty to file the application for condonation of delay within 10 days. Otherwise, the main application shall stand dismissed, my lord. But my lord, the advocate appearing on behalf of the petitioner, my lord, did not take the note of the timeline which granted by the honorable tribunal, my lord. He filed, my lord, the application for condonation of delay beyond the time allowed by the honorable tribunal, my lord. My lord, the tribunal rejected the application for condonation of the delay, my lord, on the ground that since the application, the main application stands dismissed by virtue of the earlier order, my lord. Therefore, this application for condonation of delay becomes infructuous.
How many days delay in filing that application?
My lord, it was filed in August, so my lord, it will be around one or 2 months, my lord.
The appellate order was passed on 6 July 2018.
6,555 days, my lord.
6,755
days. We have filed application for condonation. 6,555 days.
55 days.
Yes, ma'am.
Or 655 days.
655. 655 days, ma'am.
My goodness.
Well, because of the, my lord, one advocate, my lord, who was octogenarian, my lord, he's my lord, jumbled up this appellate order with the file of some other advocate, my lord, Mr. B.N. Saraf. Thereafter, my lord, the petitioner went to his office, my lord, to take the letter. He came to know that he has expired, my lord, that advocate, my lord. That we have explained, my lord, in our application for...
Where is your application for condonation of delay?
My lord, it is at page 60. And my lord, the explanation starts from page 63.
You first show the ex parte on the original draft assessment order.
But kindly come. My turnover was, my lord, 60. Draft assessment order is at page, my lord, 43. My turnover was, my lord, 75 crore. It was enhanced to 100 crores, my lord. And entire claim of input tax credit of rupees 3 crore 35 lakh was disallowed, my lord. But if I get one opportunity, my lord, so use amount, my lord, 15%, my lord, it comes to around 1 crore rupees, my lord. Business will be, my lord, ruined.
No, how do you say that this pre-deposit you need not comply? Yeah, ultimately, so the what?
My lord, kindly see on the top, my lord, your lordship will find there is a outward memo. It was issued on 20th.
That's on merits. That's on merits. The assessment order dated 27th of February 2018.
Yes.
Is considering, because you did not show cause against the proposed assessment.
Yes.
According to you, you say notice was not served, that's on the merits of the matter. But ultimately, the challenge is to an assessment order.
Yes, yes.
So one of the grounds of challenge is that the notice of the pre-assessment notice
Yes. Well, law
was
requires
not served.
well,
That cannot be a ground. If you pay 15% of the disputed tax, we'll restore your appeal before the senior joint commissioner.
well, kindly
It is worthwhile.
well, I am leaving
It is worthwhile.
leaving it to your
Definitely
lordship, but the amount is too high. Well, kindly consider
What
this.
to do?
Well, kindly consider. It's an ex parte order, my lord. 4 crore 59 lakh is the demand, my lord. The entire claim of input tax credit is disallowed, my lord. 3 crore 35 lakh. 15%, my lord, is applicable when the time of 7 days is allowed to file the rebuttal against the draft assessment order, my lord.
You are not able to produce any documents. Movement of goods has not been proved.
But that I will produce, my lord. I have all the documents, my lord. The seller, it is not the case, my lord, that the sellers were non-existent or sellers were fictitious.
Even if you go before the tribunal, assuming the tribunal condones the delay,
yes,
and then it will remand it back, once again the same order has to be passed.
No, we are in possession of all the documents, my lord. Only one opportunity, my lord.
So this writ petition has been filed challenging an order passed by the West Bengal Taxation Tribunal dated 12th August 2024, by which an application filed by the writ petitioner for condonation of delay of 655 days in filing the appeal before the tribunal was dismissed. The appeal was preferred before the tribunal, challenging the order passed by the appellate authority, namely the Senior Joint Commissioner, Commercial Taxes, Bali Circle, dated 6/7/2018. By the said order, the entire input tax credit availed by the petitioner has been disallowed. By the said order, the assessment order dated 27th February 2018 was affirmed on a technical ground that the writ petitioner has not paid 15% of the disputed tax at the time of filing the appeal. So far as the application for condonation of delay is concerned, the petitioner has assigned certain reasons which, according to the petitioner, was beyond their control, and they have prayed for condonation of delay. In any event, the delay is inordinate, as it is 655 days. Be that as it may, the appeal filed before the appellate authority was dismissed by order dated 6/7/2018 on a technical ground that the petitioner has not deposited 15% of the disputed tax as required under section 84 (1) of the West Bengal Value Added Tax Act 2003, read with Rule 138 (2) small b small ia (close) of the West Bengal Value Added Tax Rules 2005. Mr. Dugar, learned advocate appearing for the petitioner, would submit that the petitioner is not required to make the pre-deposit of 15% of the disputed tax, since the notice along with the draft assessment order was not signed. We are not persuaded to accept the said submission because the said contention is a contention that has to be agitated on the merits of the matter, and this cannot be a ground to refuse to comply with the statutory mandate under section 84.
Rule 138 says, my lord, this that 7 days time.
180 statutory mandate under section 84 (1) of the Act, which provision has already also been upheld by this court. Considering the fact that the assessment is a high-pitched assessment, and the assessment was ex parte since the petitioner did not appear, and also taking note of the fact that though the final assessment order was passed on 27th of February 2018, till date the same has remained a paper order, and the government has not been able to recover any tax, we are of the view that one more opportunity can be granted to the writ petitioner to pursue their appeal before the senior joint commissioner, commercial taxes, Bali circle, provided the petitioner complies with the pre-deposit condition by paying 15% of the disputed tax. For the above reasons, the writ petition is allowed and the orders impugned are set aside, including the order passed by the Senior Joint Commissioner Commercial Taxes dated 6/7/2018, subject to the condition that the petitioner pays 15% of the disputed tax as required under Section 84 within bracket 1 of the Act within 15 days from the date of receipt of the server copy of this order. Upon remitting the amount, if the petitioner files the challan evidencing payment, the appellate authority shall restore the appeal to his file and hear the appeal on merits after affording an opportunity of personal hearing to the writ petitioner. In the event the writ petitioner fails to comply with the above direction within the time stipulated, the benefit of this order will not inure to the petitioner and the writ petition would stand automatically dismissed without reference to this court.
Grateful. Kindly consider the amount of my lord 15%.
No. You can, sir. You are appearing, your client will pay.
I'm grateful, my lord. Well, time for 1 month, my lord, 15 instead of 15
All right,
days.
within
Holiday.
30 days.
I'm grateful, my lord.
Serial number 5.
Your Lordship, I am appearing for the appellant. Your Lordship, this matter pertains to denial of ITC on the grounds of retrospective registration cancellation of the supplier. Your Lordship, in the last occasion when the matter was heard, Your Lordship was of the view that there are many judgments addressing this issue. Your Lordship, we are preparing a compilation of those judgments wherein ITC cannot be denied on the ground.
Where is the compilation?
Your Lordship may kindly take up the matter on next Tuesday.
After vacation, my lord.
All right. At the request of the learned advocate appearing for the appellant, to give a date after vacation. Next.
Let that compilation be given to us.
Yes, in advance. Soft copy only, no hard copy.
No soft, yes, soft copy.
You share the soft copy.
Your Lordship.
When Mr. Ankit is appearing, normally all the judgments are part of the petition.
No, we have requested him,
Yes,
please don't
Yes, my
bulk
lord. He has all the judgments. It will help us also.
Next.
Grateful to Your Lordship.
Serial number 6.
My lord, I am appearing for the appellant, Your Lordship.
Where is your application?
Lordship, two things. First, Your Lordship, the application, Lordship, because I was not well for the last 4 days, my lord, that has not been ready. That is because of me. And my lord, the second thing that in regard to the opposition to be filed in respect to the writ petition, Lordship, we don't need to file, Your Lordship, the opposition, because whatever we have stated in our stay application, Your Lordship, that will be our contention in respect to the writ petition. Lordship, the matter could be heard finally on any day as per your convenience of Your Lordship. In the meantime, I'll be carrying out a formal application for the
First you file
substitution.
the application
Lordship.
to bring the substitute.
Lordship, I have got the names. I have written letters. I have got the names of who are the person to be added as a party, Your Lordship.
Essentially, it's our fault, Miller. So only will some time, Miller, because
The learned
substitution
advocate
unless and
appearing
until
for the
done, Miller.
appellant. It was for 3 weeks' time to file an application to bring to substitute the legal heirs of the deceased first respondent / writ petitioner. Time for filing such application stands extended by so and so. List after
Lordship, I pray for his Lordship's father's
Lordship, my senior condolences.
condolences to his Lordship. Yet.
Serial number 7.
I appeal for the petitioner, my lord. Local Bhattacharya is the petitioner.
What is this? Some assigned matter?
Lord, this was, my lord, against the honorable speaker, my lord. He is on legs, my lord.
Now, where are the other petitions pending?
Lord, actually, the advocate on record, my lord, is not here today, my lord. May it be, my lord, passed over for the day, my lord?
Because they filed a SLP in the Supreme Court.
My lord.
That was withdrawn. permission with liberty to take recourse to appropriate remedies in accordance with law, including filing of a petition in the High Court and making an appropriate request for his analogous hearing with the pending matters. WPA 3629 of 2022 is allowed. Parties are at liberty to mention WPA 213 of 21 as soon as the issue of disqualification number 2 is decided by the respondent number 1. We thought as and when the parties will mention the above identical matters before also will tag along with so. At this juncture, pertinent to mention here that no one mentioned as per the observation made in the operative court judgment dated 14/11/4/2022. Okay. Nobody is mentioned. That we'll accept.
My lord, made me only adjourn for the day, my lord. I'll come back tomorrow.
Adjournment is sought for on behalf of the writ petitioner. It is seen that earlier on the administratively an order was passed to calling for explanation as to why this writ petition was not placed before the division bench. Division bench. The explanation has been submitted by the officers concerned on 23/2/2024, which has been perused by us, and the same is acceptable. Accordingly, the explanation is accepted, and further proceedings are closed. As could be seen from the order dated 11/4/2022 in WPAP 213 of 2021, this matter has to be tagged along with the said writ petition. The Honorable Supreme Court, while disposing of special leave petitions C diary number 39707 of 2022, filed by the very same writ petitioner by order dated 24/2/2023, while granting permission to withdraw the special leave petition, granted liberty to the petitioner to take recourse to appropriate remedies in accordance with law, including filing of a petition in the High Court and making an appropriate request for its analogous hearing with pending matters. Since there is also a direction passed in WPAP 213 of 2021, both the writ petitions have to be heard together. Accordingly, this writ petition in WPA 6193 of 2023 be tagged along with WPAP 213 of 2020. Next.
Serial number 8.
My lord, at the outset, my lord, accept our heartfelt condolence, my lord, for the loss my lord has suffered. Which is sad to know that.
Yes.
Your Lordship, after the petition, I'm praying for short passover. Your Lordship, in this matter, I'm led by Mr. Devjit.
12:30 original say. What is
contempt
application? Notice has been served.
Everything is ready, only to hear out. According to me, my lord, there is no contempt.
Immediately after.
I have no problem.
Already. At request of the learned advocate for the applicant after give a date. Next.
Serial number 9.
This is my contempt petition, my lord. This is in respect of the subsidy. Where, my lord, they had gone up to Supreme Court, both SLPs dismissed. Previous occasion, it was submitted that they have filed a review petition. It was served on us, my lord, but then we find that it's not in the list.
Last occasion we said the review.
Yes.
But I think that was the direction.
Yes.
My lord's last order has not been signed, possibly. It's not been uploaded.
Not signed.
Not uploaded in the server.
Today I will sign. That was on 3rd December.
3rd of December.
Today
This
only
is-
I
we
signed.
have, we
Today
quite
only I
appreciate.
signed. All right. Let this contempt application
You have served on 3rd of
be
December.
tagged along with
No, no, to bolo
review application filed
Yeah.
by the state.
So,
Today morning only.
no, no. We have
By
been
the
served,
state.
but this is not পুরোটাই বলেছে।
last
আগের দিন
order.
তুমি ইয়ে করতে বলেছিলে, আসেন।
What is the review application number?
RVW number?
এই RBW নাম্বার গুলো দেন।
Double
RBW 336 of 2024.
and there are 2 CAN applications along with that.
তো একসাথে চলে আসে।
Along with the connected applications. You give a date immediately on the opening date.
Immediate laundry. Well, my instructions are that possibly their review petition may be defective, but let them cure the defect, otherwise it will never come up in the list. Mala. Let them cure that.
Okay, I told you it is clear.
It has been cured.
Next.
Grateful, Mala.
Milord, may I only interrupt the court for a moment, Milord. There is another review application in respect of another matter. May both the review applications come, Milord, one after the other.
Deal it one by one.
Very nice.
Serial number 10.
Yes.
At the outset, Milord, expressing deepest condolences to your lordships. Now, this is
And what is the
alleging
contempt committed?
contempt of an order.
My lord, I have been served with no copy of the contempt, my lord.
Not against you. Why is it issue?
The contempt is of an order dated 9th of May 2024 at page 20.
Contempt is
If and by
Please see
next.
page 21.
Yes, we have signed.
It is against.
Still he is continuing his register.
Actually, I should inform your lordship that the
superannuated, perhaps superannuated.
no, he has been arrested.
Arrested.
He was taken into custody in connection with another case, but definitely, Milord, same allegations, Milord, for giving fake degrees. Now he has been enlarged on bail. He was in, Milord, after 40 days in custody.
Then reinstated as register.
That, Milord, is for the state. That, but
No,
he has,
I am not for the state, my lord. I am for the person whom they have alleged. But my lord, this order passed by your lordship was passed, my lord. My lord, they have suppressed the entire thing before your lordship, my lord. There has been order by, my lord, this honorable court dated 27 July 2023. I have to copy now. My lord, kindly see wherein, my lord, he has been reinstated in his job as the registrar. Thereafter, my lord, they have challenged that order before the honorable division bench. Honorable division bench of this honorable court, my lord, has rejected their appeal. My lord, kindly see, suppressing all these facts, they projected in such a way as if I have been, my lord, in the office, my lord, in spite of the fact that there have been severe allegations against me.
Our candidate is also.
My lord, knowing, my lord, what they have done, your lordship, they have filed an application before your lordship as well in the PIL, this instant PIL as well.
And 8.
That they did not praise or that was rejected.
No.
Thereafter, your lordship, thereafter, I'll show the orders. My lord, suppressing all these things, my lord, they obtained that order.
Nothing prevented my learned friend, if he is so aggrieved by the order,
absolutely,
from not seeking a recall of it. But I do not know.
It is your appeal. You have appeared in this.
Yes, their appeal.
Yeah. Then you pursue your matter against this. You challenge before the honorable.
My lord, then also there was a recalling application against the order of the honorable single judge. That is pending. We have filed our opposition. Suppressing entire thing, my lord. They came before your lordship.
The orders passed by the division bench in MAT 1569 of 2023.
May I just
this contempt application cannot be pursued by the present application. Therefore, the same is dismissed. However, the dismissal of this contempt application will not prejudice
this order is prior to the contempt.
the petitioner from pursuing other remedies which are available.
Deeply obliged.
You move that application. Next.
Serial number 11.
I beg to appear, my lord, on behalf of the alleged contempt number 1 and 2, my lord. First of all, my lord, I pray for unconditional, sincere apology, my lord, for not appearing twice pursuant to my lord, sir. However, my lord, pursuant to my lord's direction, my lord, with the intervention of the panchayat, the private parties, the jheel owners, my lord, somehow, my lord, some workable road has been constructed, and the panchayat authority also, my lord, requested the block development officer to place a fund and project, my lord, because of the, my lord, it takes up the
11th of July 2023, your lordship's order, parent order. Page 33.
If my lord takes up the photographs, both sides
The
of the
second
road.
round of litigation.
There is a direction to the respondents 9 and 10 in the writ petition to implement the directions of the block development officer in its order dated 13th January 2020.
The private owners, my lord, are required to.
My lord, an ambulance going road had it been turned into this situation.
The difficulty is.
This was
my
an
lord,
ambulance going road, my lord.
My lord, the difficulty is both sides of the road are jheel. And it is water body. So, my lord, we have approached to the. It is not. It is a big project, my lord, because my lord,
Then you should have gone before the block development
Yes, my
officer.
lord, already, my lord.
You should have given the proposal saying that,
Yes,
sir,
already
this is not
proposal, my
feasible
lord,
for
already,
XYZ
my
reasons.
lord, already proposal has been sent to the. We have, my lord, at the intervention of the, my lord.
Where you are the Gram Panchayat. You
Already,
have
my lord, sent
to, you have to
proposal.
work for the people who have voted you to power.
Absolutely.
Otherwise, you step down.
My lord,
Existing road that has been destroyed. Now, this is the situation.
No. You restore the road
Yes.
with the available funds. Then you write to the BDO for addition.
Already, my lord, we have wrote to the BDO, my lord, this is the workable condition. We have made it, my lord. Correct. One, my lord, kindly excuse, one is black and white. My lord,
This is not a road, sir. It's a footpath.
That's become the situation. Well, earlier, the ambulance were going through this.
This
Now,
is
it's
so
not
far
the condition to.
Show some photographs too.
Yes.
You see this?
I have seen.
No. You show this photograph.
Yes.
Present condition.
Yes. Road is, my lord, 4 feet wide. My lord,
And who will appear for the state?
my lord, we have
Except, my lord, two-wheelers, nothing can run.
Nothing. Two-wheeler also difficult.
difficult. My lord, the both side, my lord, embankment is required. We approach
Enter
the
village is
development officer for making a project and sanctioning of some funds. Concrete road so that it can be, my lord, it can be done, my lord, in proper way. My lord, now the state can, my lord, answer.
Hey, you file an affidavit.
Yes, my lord. We
File an affidavit.
But it's
Then,
my instruction is it was covered under NRGS project for construction of concrete road. Somehow, my lord, I don't know what's happened with that
And
project.
whether the block development officer is a party in the contempt, no.
No, my lord, the DM is a party because he was directed to supervise the entire issue.
But can you serve notice on the government council?
Yes, my lord.
And who appeared for the DM in the writ petition?
Mr. Nonchad Bihani, my lord, appeared at the time.
You can serve him.
Yes, my lord, I shall.
The learned advocate for the applicant is directed to serve notice on the learned counsel appearing for the state who had appeared in the writ petition, who had appeared for the state in the writ petition. Though in the writ petition, namely WPAP 326 of 2023. The learned advocate appearing for the alleged contempt
I'm sorry, my lord. Respondent number 4 is the BDO in contempt petition.
You are appearing for respondents 1 and 2.
1 and 2, my lord.
The alleged contempt are namely respondents 1 and 2 submitted that the road in question has now been made into a usable condition. But since there are water bodies on either side of the road, funds have to be sanctioned by the block development officer, for which proposal has already been forwarded. Let an affidavit be filed by the respondents 1 and 2, clearly setting out the stand as to why they have not complied with the direction issued in the writ petition. List the matter. You give 3 weeks time. In the meantime, you serve the.
Yes, Malaysia. Great.
Okay.
Serial number 12.
May I, my lord, hand over this or with my lord?
With the
With the affidavit.
My lord, I am
Great.
for the, my lord, my lord. My lord,
I am for the.
the order passed by your lordships, my lord, page 19. My lord,
I am for
direction on the respondent number
3, my lord.
4, 5 and 6 to take necessary action so that the, my lord, factory can be shifted from the village to another elsewhere.
What happened?
My
I
lord,
am for
nothing
the
has been
respondent
done.
number 3, my lord. The Prodhan. The Prodhan has already taken steps, my lord.
And stop work notice has been issued, my lord, and the factory has totally stopped.
My lord, last page 30 to 32, my lord, the present photograph shows that, my lord,
Now, the Gram Panchayat has issued an order. They have stopped all operations and have directed them to shift.
my lord.
Have they shifted?
No.
I have the instruction that not shifted, but the work function of the factory has been stopped.
All right. Then you don't want to run the
No, my
factory?
lord. Whether he will shift it or not, that is their business.
No.
But
Then
the
you
factory is stopped.
Then you dismantle the machine. See, if the factory is stopped, suddenly after 2 months, 3 months, you'll start operation. That can't be done.
My lord, my instruction is that, my lord, very recently,
Regarding
my lord,
demolition,
very recently, my
Panchayat is the
lord,
authority, my lord. Regarding demolition of the factory, Panchayat is the authority, my lord.
You approach the Panchayat.
Yes.
No, see, already they have issued an order directing you to close. You have closed. There is also a direction to shift the factory to a different premises.
Yes.
You don't require any further permission.
No, Panchayat
has, you give a copy of that.
He is appearing for the Panchayat.
You give a copy of this letter. This concerns a factory which has been put up by the alleged contemnor. Which was directed to be closed down. The director also issued for shifting the same. The direction is being complied with by the Gram Panchayat by issuing an order dated 23/7/2024 by which the factory which was being run by the fourth respondent contemnor herein has been directed to be stopped, and there is a direction to shift the factory. The factory it is not in dispute that the factory has been closed, stopped, and there is no manufacturing activity, but it is yet to be shifted. The fourth respondent is directed to shift the factory within 4 weeks from date in the event to an unobjectionable place after obtaining requisite permission for the said new location. In the event the fourth respondent does not propose to run the factory any further, all the machinery shall be dismantled within the said time, and the Pradhan of the Gram Panchayat shall conduct an inspection and file a report before this court. Give a date after 5 weeks. Next.
Serial number 13.
Grateful. 14. First time was coming.
12 and 13 same.
None appears for the applicant. Even on the last occasion, none appeared for the applicant. As recorded in the order dated 3/9/20. Dismiss. Next.
Serial number 15.
14, 14.
14.
14, my lord, this is my application.
14.
My lord, this is the first time, my lord, contempt application.
What is the contempt, sir?
My lord, I have communicated your lordship's order. My lord, thereafter, they issued the notice, page 50. And the
Where is our order?
Your lordship's order, I have annexed, my lord, page lordship 31.
31.
But no decision was taken up by them. At least no communication was made to us. Notice was issued, I appeared.
Where is the notice?
Notice, lordship, page 50.
50.
Relevant portion, page 52. Last page of my application.
You You were directed to appear on
We
27th
appeared.
of July. You have appeared.
But no communication was made with their decision that ought to have been communicated as per your lordship's direction.
And who will appear for the state? Somebody can appear. Chakraborty, you can appear. You get instruction in the matter. Executive Engineer, Diamond Harbour Highways Division, PW Roads Directorate. Mr. Tanmoy Chakraborty, learned advocate.
Executive Engineer and
appearing
Executive Engineer
for the state
PWD.
is directed to obtain instructions. Is directed to obtain instructions from the Executive Engineer, Diamond Harbour Highway Division, as to what steps, what steps, further steps were taken pursuant to the notice of notice dated 24/6/2024. The appearance of Mr. Chakraborty shall be regularized. Give a date after 2 weeks. You serve copies, sir.
Yes. In course of this day, I said.
Yes. Let copy of the contempt application be served on the learned counsel for the state during the course of the day.
Grateful.
Next.
Serial number 15.
I'm doing after vacation.
All right, after vacation.
Great.
Serial number 16.
This is the Tram matter.
Yes, Tram matter.
I have.
This is tagged with the pellet side matter.
Yes.
Contempt. It's about bituminization of the tram tracks. The lordship said that
My contempt
We
application.
passed an order.
that tram tracks should not be bituminized, and a committee was set up. Now, they have more or less disbanded the committee. Committee is saying nothing, and the tram tracks are being bituminized, at their own
If
way.
there is a will, there will not be a way.
My lord,
In fact, did the court officer share one
kindly see the order at page
which I had
43.
forwarded?
My lord.
Now, in somewhere in the somewhere abroad, they have implemented. Brought back the trams, which will not run on rails. It will run on tires.
And there is a magnetic.
I don't know. I saw that article. Where is
But I
bringing back the tram,
But I have also seen that. But please consider, modernization of tram, the money required, whether we have the resources or not.
Have, sir. You have, sir. You can, sir. Certain things we need to preserve for the future.
But we are preserving it, as a heritage one.
My contention here is that.
Not heritage.
But it is it's no more,
That is why, with a fond hope, we constituted a committee, made her also a part of the committee.
My lord, without informing the committee, my lord.
There is a YouTube channel, no? Tram is sane. Huh? I've been watching that regularly. And there's very recently a wedding took place in the tram. About 2 weeks back or 1 week back.
My lord, they should have, my lord, informed this honorable court about that, whether what
No,
was
what
their
happened to the committees?
Can you see page 50 below the order is there? Constituting the committee.
Yes.
No meeting.
But I've told the
January.
committee is meeting from time to time. Of course, we had the
So
last.
after January, there is no meeting.
Let this submission not be made. Let it take proper instruction. Standing up and saying committee is meeting from time to time.
How does he know I have not taken any instruction?
His instructions are incorrect. From January, the committee has not.
See, this person, should not make allegations against the members of the bar. In every matter, he has got a habit to make allegation against the members of the bar.
Let us do.
Kindly see order.
Why does he take everything personally?
No. This is something the committee has not met from
He's
January.
so passionate about the matter.
You're in
That's why-
December.
We understand the passion.
Time
But
what? Time to time means you met in October, November.
We have taken out an application.
No, let
January
us.
he has not met.
No. Where is the order constituting the committee?
It's set.
Page 50. 7th August 2023. Page 50 of the application. In the appellate side. Both are tagged, my lord. Original and appellate side matters are tagged. The appellate side lordship is page 50.
Give that appellate side.
7th August 2023. That is the order. We have heard the learned senior advocate appearing for the petition and learned advocate general appearing for the state with the consent of the parties. Advisory committee consent. Can you see, my lord?
petitioner is there and
Which order?
Mr. Pradeep Kakkar, representative public is also there.
আমাদের ম্যাটার এই হচ্ছে
My information is, my instructions are that from January, the committee is defunct. Not defunct, it's not being convened.
It's not met.
Not met. And this bituminization is being done without informing the committee. It's not a decision of the committee that bituminize all the tracks.
We don't have that order. Page 50 is it?
I mean, it's the appellate side matter, my lord. Your lordship, perhaps taking the original side. You both were tagged.
Both were tagged together, my lord.
Yes.
This order was passed on 7th August.
7th August, page 50.
Where is the other matter?
by the committee. You have the contempt application. Order appointing the committee. First order.
And the order
This,
against which
this
contempt is
committee
taken-
was constituted with the consent of the state
Is
and
this-
all parties.
And the learned Advocate General at that point of time may not appeared. Can you see, my lord?
All right. We have heard the learned senior advocate appearing for the party.
But we have taken out, my lord, and can,
Ah.
my lord, for recalling of the order of 8th
That
of
we will
May.
consider after the committee placed
Very
that's what,
Yes.
senior advocates appearing for the contempt applicants and the learned advocate general appearing for the state. By order dated 7th August 2023 in WPO P12 of 2022 with WPAP 214 of 2023. With the consent of the parties, an advisory committee was constituted comprising of 11 members. It is alleged by the learned senior advocate appearing for the petitioner applicant that the committee has not met after January
4th January.
after 4th January 2024.
2024.
It is not clear as to why the committee has not met, despite the fact that the committee was constituted with the consent of the state after much deliberations and discussions, and also after hearing the then learned advocate general appearing for the state. It is all further submitted that despite an order directing that the bituminization of the tram track should not be done, or the track should not be dismantled, in certain portions, it is alleged that the bituminization has been done, that too without even informing the committee or without taking any permission from this court. The learned advocate general submitted that an application has been filed in Can
1 of 2024.
Where is that application?
In the appellate side matter, they have.
But in the appellate side, but
All right. In Can 1 of 2024, in WPAP 214 of 2023, for recalling the order by which the state was, the respondent were restrained from bituminizing the tram tracks and removing the tram tracks.
that's 8th of May 2023.
That's the said application will be heard after the committee constituted by the order dated 7th August 2023 files a report before this court explaining as to what was the placing all the minutes of the meetings of the committee which have been held prior to January 2024, and also explaining as to why the committee has not met after January 2024. We make it clear that in the event the explanation offered is not satisfactory for not convening the meetings of the committee, the court may be constrained to pass certain adverse orders. It is reiterated that until further orders, there shall not be bituminization of any further bituminization of the tram tracks or removal of the tram tracks, and the same shall be preserved as it exists, as on date. List the matter. We'll give them some 2 or 3 weeks time.
Can I leave it to your lordship? I don't want to say anything on the timing.
You give in the
I have
third
pointed
week,
out
week
that
starting
how the order is being
13th
executed.
January, 14th January.
14th January.
14th January.
You also direct the committee to meet before that.
Sir, one line you add. It is well open to the committee to convene a meeting before the next hearing date and place the minutes of the meeting before this court.
Before the next hearing date.
এর ভেতরে মানে ভেকেশনের ভেতরে করে দেবে জানুয়ারি মাসে তো বলা কেউ থাকবেন আপনি কি
When I was in Chennai, I saw this article. Then I sent it to Mr. Anjanda, saying that you forwarded to the advocate who's appearing in this matter. I think he didn't send it to you. Lahiri also, you didn't get it. It's worth the investment, sir. If it's a PPP module or a project, there will be a lot of people who will be interested in
But the
taking.
problem is that as we find, at least as a citizen, I find tram is no more being availed by the general
No,
public.
you make it attractive, it will be availed. See, now that in certain areas you have already pulled it off. In certain other areas, after the metro work is over, of course, they have obtained an order from the Supreme Court not to fell the trees.
Yes.
And some direction has been issued. But still the work is going on. It will be a great tourist attraction. Like people throng for hanky carriages. It will be a great, and if you make a private partnership, they will do the investment. In fact, the coaches have to be replaced. You've got wonderful coach building factories. ICF is, and they use latest, steel, which are lightweight plus impact resistant. Speed can be improved, air condition facility with large windows so that you can definitely, and you charge a premium, doesn't matter. No, not on the rates which you are operating now. That is why it's not.
Well, the assessment which I find made by the state does not seem to be that encouraging in reforming it and put it in
Now
place.
in Baliganj, in old Baliganj, the first tram was about 6:20. It will cross that CCFC. That by 7, it is 40% full. Up to at least, or I have seen on Saturdays also up to 10:30 or so. Then there is a lull. Once again, from 3 p.m. to 6 p.m., 40 to 50%. But if you increase the speed, provide better amenities like good cushion seats or something like that, fan or air conditioning facility, definitely people will. See, people who are not racing against time, definitely they will avail.
Well, what is happening, I'll tell you, Lordship. First is the tram tracks are in the middle of the road, which number one creates accidents. Like the bicycle riders, once the tire comes within falls within the track, they tend to fall, which is also applicable to scooters. Number two is during the rainy season, because of the water, again, there is a scope of slipping. Number three, which is very important, is we don't have like bus stoppages, we don't have tram stoppages. This is all in the middle of the road. People have to, board and come out of the trams aligned from the tram in the middle of the road.
In fact, if you had gone to Bangalore,
yes,
the bus
yes,
bay is in the middle of the road.
Yes.
But they have got a underpass.
Yes, one or two underpasses are there, but
you alight from the bus, get into the underpass, and it will go to the
other side of
the road or this side of the road.
Yes.
I don't know, sir.
We have made an assessment, but we place it before your Lordship. What are the difficulties?
Can I just say one thing? When there is a will, there is a will.
No, definitely.
There should be a political will. If there's a political will, definitely it can be done. There will be a lot of private players who will be interested because advertising space, etc.
Otherwise, without this participation,
Well, we find from the very first, unfortunate to say, from the very first, there is the distinct reluctance on the part of the state government.
No, it's not the reluctance. It is the gross reality which my learned friend should also understand.
Let the committee decide on what.
Today, we have the metros.
And they desire to bypass the competition.
We have the electric buses.
As of now, I think only in 8 routes or 10 routes.
As of now, I'm told there are 4 routes.
4 routes. you preserve those 4 routes.
My lord,
Out
we
of that-
intend to, my lord, preserve, my lord, the heritage which will be, my lord, from Khidirpur to the Maidan.
There is a reason for that. I don't want to go.
And my lord, from the Maidan to, my lord, the Nunapoku Tram Depot we call, so that for, my lord, workshop purposes. This is what, my lord, we intend to preserve.
But these tram depots which are not used
Yes.
are
Yes, we need to, my lord, utilize those also.
hiding den for
Right.
antisocial.
Plus mosquito breeding
of
grounds.
iniquity. Then of iniquity.
All right, let us see.
Let us see what happens.
Next.
I'm getting number 17.
I don't want to say anything which offends the Advocate General.
No.
I'm making it very clear, my lord. I appeared in Madras High Court before the Chief Justice who's come from Bombay. And my lord, I was very pleasant. He thought that are you so pleasant in Calcutta? He asked me, are you so pleasant or outside court you are pleasant or you are pleasant in Calcutta? I said, please ask the Chief Justice, he's from Madras High Court. That's what I told him, he kept quiet.
My lord, you offered lordship condolence in the lordship's recent bereavement.
Yes, my lord. I
behalf of
forgot
the
I should have
past.
started, my lord. Bereavement, in the lordship's recent bereavement, please accept my heartfelt condolence.
You offer the condolence.
I should have started by saying that, my lord, I'm sorry. I was a bit carried away. To that extent, he's correct.
This is my application for contempt, first time. Order is at page.
Who has committed contempt?
My lord, your lordship, in earlier proceedings, a direction was given, my lord, upon the commissioner to do certain things. Commissioner passed an order. That has not been stayed by any court. Then, my lord, I moved this application. My lord directed, my lord, the authorities, if your lordship, page 19, it starts. 22nd of February 2024. Paragraph 2, if your lordship kindly have a see. Very clear.
But
Therefore,
what is the WPA 812?
Yes.
What is that writ petition?
The allegations brought against the private respondent number 11, he has challenged this, and your lordship recorded specifically there is no stay order, the order has been withdrawn. Therefore, it is free, the commissioner is free to proceed with that. Now, my lord, this private respondent is not turning around, so as a result, my lord, there cannot be any audited accounts. My lord, I beseeching your lordship.
And who appeared for the state in the writ petition?
My lord, in the present writ petition, I appeared.
No, for the state.
State, my lord. My learned AG with Vishwabrata Vasu Mallik and Minalini Mojumdar.
Then you serve notice on the counsel for the state.
My lord.
The learned advocate for the applicant is directed to serve notice in the office of the government pleader to enable the learned government pleader to get instruction from the authority as to what action has been taken pursuant to the order passed in WPA P65 of 2024 dated 22/2/2024. Let copies be served in the office of the government pleader within 2 days from date. List the matter on 14th January.
My lord, may I serve upon the learned advocate who appeared in earlier proceedings?
Whatever it is.
My lord.
Some counsel should appear on the next date.
My lord.
To ensure that.
Now there is.
We'll finish 2 more with contempt will stop.
Serial number 18.
I am for the petitioner's contempt application for the first time. Your lordship's order dated 16th of October 2023. Direction was upon the Director General of Police to take a decision on the basis of recommendation made by the additional superintendent in respect of inclusion of 11 Moses into newly created.
Where is the question of contempt in this?
Kindly
He
come.
said appropriate decision on merits.
That has not yet been taken. That has not yet.
We
This
can't
is the
compel.
second writ petition, my lord. First writ petition, your lordships directed. Accordingly, they recommended before the higher authority. Now, the higher authority, they are sitting tight. We approached this honorable court. Then, my lord, they submitted the recommendation. Your lordship would please.
No, we directed the additional Director General of Police to take an appropriate decision on merits. We didn't even fix a time. Probably we will fix a time limit.
Now, my lord, that's of 16th of October 2023.
Yes.
We are in December 2024. Nothing happened thereafter. They are so reluctant.
This contempt application has been filed alleging willful disobedience of the order dated 16/10/2023 in WPAP 546 of 2023. As could be seen from the said order, there was a direction to the third respondent there in the writ petition, namely the Additional Director General of Police Headquarters, West Bengal, to take an appropriate decision on merits and accordance with law on the representation given by the petitioner. It is no doubt it is true that no time limit was fixed and decision was to be taken as expeditiously as possible. The learned advocate for the applicant submit that till date, though more than 1 year has lapsed, no decision has been taken. In the light of the same, we dispose of this contempt application by directing the Additional Director General of Police Headquarters, West Bengal, to take a decision on the representation as ordered earlier and communicate the decision to the writ petitioner within a period of 4 weeks from the date of receipt of the server copy of the search.
Great, my lord.
The petitioner is learned advocate for the applicant is directed to serve a copy of this order in the office of the learned gown pleader for effective compliance. Next.
Serial number 19.
Great, my lord.
19. This is also contempt, sir. Same Tram matter. List along with it. Item 16. Next.
Serial number 20.
I do appear for the petitioner, a case of unauthorized construction on a village road. Now, on the 18th of April 2024, your lordship was pleased to give a direction upon the subdivisional magistrate to consider the representation, make an inspection, pass a written order after hearing all the parties. 3 months lapsed. Thereafter, they issued a notice for inspection. In course of inspection, they found that yes, unauthorized construction has been made on the village road. Now, thereafter, my lord, they didn't pass on any order. They stayed their hands. They said that since a review petition has been filed, so we will not pass any order.
Page 96.
Page 96.
What happened to the review?
Nothing happened, my lord.
No. Where is the review now?
Review is before my lord, and nothing moved. They have not moved.
No. We'll list the review. List this contempt application along with RVW 249 of 2024.
My lord will hear the review.
So we will decide the review and then we'll catch these fellows.
Absolutely, my lord. It's up to you.
Yes, we'll stop with this.
On my lord, I listed, kept the matter.
When it will come?
On? Review number to reach. I'll copy document, my lord.
The learned, you add one more line.
Yes, ma'am.
The learned advocate for the applicant is directed to inform the learned counsel appearing in RVW so and so that the review petition will be heard along with this contempt petition.
We'll give the notice to the state also. We'll also the state.
Notice to the advocate appearing for the state shall also be given.
I will give the number of the review.
Yes.
Original site.
My lord, one mentioning, my lord, I am withdraw this application. Appellant already filed the Sabke Vikas Sabka Sath scheme, my lord. Therefore, I am withdraw this application. I am for the appellant.
Tomorrow.
My lord, one appeal, my lord, which your lordship has been hearing today. My lord, the execution is pending before the learned magistrate. The next date has been fixed on 9th December. My lord, this is with regard to the release of gold bars. We are challenging the order of the learned tribunal before your lordship. Now, the next date has been fixed on before the magistrate on 19th December. Now, in absence of some interim protection, the music will be started before the. Now, orally, there has been some direction.
No, we have said.
No precipitate.
Yes, this is enough. The magistrate will understand.
Doesn't understand, my lord.
If you, then you know what to do. Yes, please call.
My lord, may I permit to question my lord matters regarding my refund of my lord service tax, my lord? Is that directed, my lord, the department to refund the service tax, my lord? It has been, my lord, filed, my lord, waiting for the admission. Let this matter, my lord.
What is answer daily list? Item number 1.
How many days, sir?
My lord, I'm not the respondent, my lord.
How many days?
85 days. But my lord, delay is not explained at all. My lord, I'm not on the my
All right. We have heard so and so for the applicant and Mr. Amit Sharma and standing counsel for the respondent. There's a delay of 87 days in filing. The delay having been explained, the same is condoned. Application allowed.
My lord, I was trying to mention a matter.
Yes, sir.
Unfortunately, my video is, the court is not permitting my video to come on. This is on the appellate side, my lord, item 35. The famous affidavit has come from Mr. Kodalia's office.
Item 35.
Yes, my lord. That affidavit has come. And
so-
they have considered that there was an error on their part. So nothing remains in the matter. My lord may kindly finalize the interim order as final order, my lord. They have
So
considered.
we will item 35.
That's right. Calcutta Port Trust. Okay, what is it called?
led by Mr.
That is FMA
Shama Prasad.
743.
Yes, my lord.
Shama Prasad.
Shama Prasad.
Shama Prasad, sir.
Now, what has happened, sir, in the matter?
They have filed an affidavit saying that yes, there was a system error on their part, and that we did file a revised return, and our data is correct.
So that has to be recorded, and a direction has to be issued.
That's right, my lord. And therefore, the impute order will have to
On
be
what
quashed.
date we will have that matter?
My lord, next Tuesday.
Next Tuesday.
Because I am not here in Calcutta.
Lord, I am out of the country. I'm out of the country next Tuesday, my lord.
You can
Could it be
approach.
sometime early January.
Mr. Ghosh, you can appear.
Mr. Chatterjee can appear, the advocate, and because I have already prepared that affidavit and served it on them.
But Friday we can do.
My lord, I am not here. I am going to Chennai with my father for a treatment.
Oh, yes.
So I'll be returning on Monday night.
The Kondalia senior advocate's personal issue, he has to be away from Calcutta.
Right, my lord, because I also have a person, my daughter is graduating in the UK. Her convocation
Because
is on
affidavit
19th.
is already given.
All right. Then we can do one thing. The earliest we can fix it on 10th.
Very well.
I'm sorry, not 10th. 14th January.
Well,
14th
Higher on
January.
board.
Very well.
We have heard Mr. Ghosh, a senior advocate for the
appellant.
You are appearing for the appellant.
For the
for the respondent. Which respondent? No. We have heard Mr. Ghosh, an advocate appearing for the appellant, and Mr. Vipul Gundalil, a senior advocate appearing for the respondent department. In terms of the directions issued earlier, an affidavit has been filed, wherein it appears that the department has accepted and that an error has occurred. Therefore, appropriate directions have to be issued. List the matter under the caption for orders on 14th January.
Grateful, my lord.
I'm so blessed. I'm so
Yes.
blessed.
Item 2.
Item number 2.
Before I make my submission, I have no words to give any of the
Thank you, madam.
condolence. Yes, my lord. Even I lost my mother on 11th of this month.
This month.
And 10th and 11th, my lord.
Mr. Rai's father also.
He's day before yesterday.
I have
Also.
actually had a lot of bereavements in the revenue department. Mr. Rai's father passed away.
Her mother.
Mita Das De's mother passed away.
Few months back, my father.
My
Very
deepest
sorry.
condolences.
Same to you also.
Yes. My lord, the 67 days delay.
Respondent served.
Yes, my lord, twice. And the items have been
And we have
delivered,
heard
my
so
lord.
also. The respondent has been served, affidavit of service has been filed, but none appears for the respondent. There is a delay of
The
67 days in filing the appeal, which has been properly explained.
Issue is very innocuous, my lord.
Ah.
If your lordship kindly comes to page 7, the question of law, the SSC filed the return without filing the Form 10 IC, which is mandatory. Now, there is a circular which has been annexed to this application, and they ought to have filed it. The delay could have been condoned if they ought to have filed it by 30th of June. Now, very recently, this is a work done by Mr. Amit Sharma. I'm grateful to him. This is another circular, 18th November 2024. If your lordship kindly takes this, so their delay.
Let them appear. Let them appear. Because
It was remanded back. The tribunal has remanded back to the assessing officer.
today we will condone the delay.
Yes, ma'am.
Yes, next.
Item number 3. But I am expressing my deepest condolence to your lordship's loss.
Thank you.
I am for to respond. 165 days delay in tendering this.
What is the matter?
This is my lord unexplained cash credit under section 68.
Tribunal only reproduce the findings of CIT appeal, but
My lords, the entire amount of loan has been repaid. It is a matter which is a fact on record. The learned CIT appeal has allowed the appeal of the SSC after discussing the issue, trade by discussion, and Honorable Tribunal has only allowed the appeal, dismissed the appeal of the revenue after discussing the factual findings given by the CIT.
Page 112, paragraph 6.
But my lord, tribunal my lord, did not find into my lord, did not reach into my lord any independent filing. This is my lord only the reproductions of my lord the finding of the CIT appeal.
Page 113, third line. Learned Counsel has further brought to our attention to the relevant paragraphs of the order of the CITA to submit that even all the loans stood repaid. Refer to chart produced loans. All factuals. Please come. There is a delay of 165 days in filing this appeal. As the delay has been properly explained, the same is condoned, application allowed. This appeal filed by the Income Tax Department under Section 260 Capital A of the Income Tax Act 1961. Within bracket, the Act is directed against the order dated December 14, 2023, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, within bracket Tribunal, in ITA number 908/KOL/2023 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. 1 and 2, 3 not required. 3 and 4 not required. We have heard so and so, so and so. Their department was unsuccessful in their challenge before the learned tribunal, wherein they questioned the correctness of the order passed by the Commission of Income Tax Appeals, -27 Kolkata, within bracket CITA, dated 14/6/2023. By the said order, the CITA allowed the appeal filed by the assessee and set aside the addition made by the assessing officer by invoking power under section 68 of the Act. As could be seen from the order passed by the learned tribunal, the tribunal has examined the factual details after noting the factual findings recorded by the CITA. More importantly, the learned tribunal found that that all the loans stood repaid, which has also been factually ascertained by the CITA and reaffirmed by the tribunal. We find the order passed by the CITA to be an elaborate order after discussing all the facts. The learned tribunal has in fact quoted the relevant portions of the order passed by the CITA and thereafter independently proceeded to examine the correctness of the finding and affirm the same. Thus, we are of the view that no question of law, much less substantial question of law, arises for consideration in this appeal. Appeal fails and the same is dismissed. Next.
Item number 4.
May it please, Your Lordship. So, Lord, I am appealing for the appellant in the matter. Lord, kindly accept my heartfelt, my Lord, condolence.
Thank you.
Lord,
284 days.
284 days, but I should not be opening the matter, my Lord, at this stage because, my Lord, in this matter, I am being led by Mr. J.P. Khaitan, my Lord, Senior. And, my Lord, this is a matter which relates
Today
to...
we will condone the delay.
I am very grateful, very grateful.
We have heard Mr. Praneeth Bag, learned advocate, appealing for the applicant, and Mr. Soman Bhattacharjee, learned standing counsel for the respondent. There is a delay of 284 days filed by the delay of 284 days in filing this appeal. As the delay has been properly explained, the same is condoned, application is allowed.
But my also deepest confidence.
I'm very deeply obliged, my Lords.
Yes.
Item number 5.
My Lord, I am.
My Lord, we are also, my Lord, tendering my Lord,
Hello.
heartfelt condolence to you, my Lord.
Thank you.
Well, there are 26 days of delay in the
My
appeal,
Lord, this matter, my Lord, I have been served since I have appeared for the respondent before the tribunal, my Lord, but my appointment before your Lordship has not been regularized till date by my client, my Lord. So, my Lord, if your Lordship is, my Lord.
Appearing for the department, we can issue direction.
Yes, my Lord.
But he is a private assessee.
Yes, my Lord. My Lord. The difficulty is that, my Lord, I have not received the Wakalatnama since order has been, division being served.
But a notice has been served on the assessee.
No, my Lord. The
yes,
notice,
yes, it is returned, my Lord.
that
It has
is
not
why,
been
my Lord,
served.
the Honorable Court has
My Lord,
division
my Lord,
We can't compel Sweta to accept notice.
that is,
my Lord,
that is
actually,
on the last occasion.
last occasion, the
other
division bench has instructed them to serve
We
the notice.
requested,
Yes, my
but suppose she is not given the Wakalatnama, that will be difficult.
My Lord.
Then, my Lord,
or you can try with your client.
I have already forwarded the entire applications, my
Papers.
Lord, but the papers, my Lord, the appointment.
We'll have it immediately after vacation.
My Lord.
By we'll see. The learned advocate, no, Ms. Sweta Mukherjee, learned advocate was requested to accept notice on behalf of the respondent. It is submitted by the learned advocate that she is yet to receive the Wakalatnama from her client and awaits instruction. Let the matter appear on so and so date.
immediate service I have filed, my Lord. Let it be kept to the record.
My Lord, I have already forwarded the communication. My Lord. Grateful.
Item number 6. I am for the appellant.
No.
Your Lordship, I am appearing in behalf of respondent 6 and 7. Seeking short passover.
Well, the delay has to be condoned. The delay of
Your Lordship, he is busy in another room.
He wants a passover.
Short passover.
Arun Upadhyay, I have
Yes,
spoken
yes.
to him, my Lord.
He is busy in court number 36.
I know. I have spoken to him. So he has no problem in if the condemnation
Who's
is allowed.
appearing for the respondent?
The Arun Upadhyay.
Mr. Upadhyay.
Yes, my Lord. My Lord, I have spoken to him. My Lord, he did not have any objection.
All right.
If
That
they-
is that will take care.
Yes.
But this was challenged only on the ground of non-compliance of 151(3).
Yes.
What is your ground on your appeal? How do you get over this factual finding recorded by the
I will have to, my Lord, take your Lordship through Rajiv Bansal judgment, Lord, which parties we have mailed, my Lord, with officer, my Lord. But
all right, we'll pass over. Let us see. Pass over.
Oblige, Your Lordship.
My Lord, it will take some time, maybe after vacation.
All right, after vacation. Next.
Item number 7. 7 is also mine.
Same.
Same.
Next. 8.
Item number 8.
We convey our my Lord, heartfelt condolence to your Lordship.
Thank you.
My Lord, the order dated 3rd of October 20. The impugned order dated 3rd of October 2024 is under challenge. And, my Lord, this matter has been taken up by the coordinate bench presided over my Lord Justice Harish Tandon, sitting with the my Lord Justice Bhattacharya. It was fallen from Justice Bhattacharya that, my Lord, the order impugned before the, my Lord, the Honorable Single Judge, dated 27th of March 2006, has been communicated in the year of 2024. The question has been put to me by Justice Bhattacharya saying that whether this point has been dealt with by the Honorable Single Bench or not. I have examined the order. It appears that, my lord, although it has been mentioned few lines, but on that point, my lord, that has not been dealt with. So, my lord, it was Justice Bhattacharya's observation that if your lordship pleases to, my lord, set aside and remand back to the, my lord, the Honorable Single Bench for the reconsideration, I don't have any difficulty. But if the merit of the matter is concerned, I am ready and willing to argue.
But respondent has been served.
Yes, he entered appearance. Mr. Nag is appearing all along.
I am led by Mr. Shubhankar Nag. He is coming.
He is coming. No, please.
So, my lord, only thing is this, my lord, the order which has been passed by the Honorable Single Bench did not consider certain aspects which ought to have been considered by the Honorable Single Bench. The preliminary issue which has been raised that there is a provision of the appeal as to why appeal has not been preferred. My point was this is an order dated 27th of March 2006. After passing the order has been communicated in the year of 2024, which I have taken specifically in the, my lord, the writ petition, paragraph 25, 26, 27. Subsequently, although that has been placed, there was a erroneous observation in the impugned order saying that my lord, the order has been communicated to me. But
the learned single judge records that your client had participated in the proceedings.
I am coming, my lord. I have participated. The, my lord, initial proceeding was started in the year of 1994. Subsequently, since, my lord, estate officer was not there, matter was kept pending till 1998. Then on the 1998, I was not aware whether the proceeding was going or not. So no notice, subsequent notice was not given after resumption of the charge by the estate officer. Then successive notice has been issued saying that although the notice is being served, nobody is appearing on behalf of the, my lord, the appellant before your lordship.
No. The order was passed sometime in 2006.
My lord.
Your case is it was not communicated till 2024.
My lord, the document appears they have communicated the order 6 Jawaharlal Nehru Road address, but it is not my address. My address was, notice was of 5 Jawaharlal Nehru Road.
But what were they doing from 2006 till 2024? They have not enforced the order.
They did not enforce the order.
You continue to be in possession.
No, I have surrendered the possession 1983. That's why I don't have any interest. I did not inquire what is going on over there.
And this is a claim for damages.
This is the claim for damages. They have raised the damages, but it is their case. The initial proceeding has been drawn on the basis that they were under an impression that I am in occupation. When the proceeding was going on, whether I was in possession or not, since, my lord, the notice has not been served upon me. So they were, my lord, inquiry has been started.
The same ground you could have canvassed before the appellate authority.
Correct. But, my lord, that ought to have been done within 12 days from the date of the certified copy of the order.
There is no power to condone the delay. So you can always say that from the date of knowledge, my writ petition was within time. But the writ petition was dismissed on the ground of
no, writ petition was not there. My writ petition was not there. Initially, I have participated in the proceeding.
No. According to you, you came to know of the order only in 2024.
Correct.
Assuming within 15 days after date of knowledge, you had filed the writ petition. This plea can be raised and the correctness can be examined by the authority by calling for the original
There
records.
is, my lord, the difficulty. Initial demand was 1,82,000 on odd figures. Subsequently, they multiplied it, saying that the interest and all those things, that is 13 lakhs and odd figures. Now they are demanding 50, my lord, the 8 lakhs and odd figures. I have to deposit the 50% of that amount. So therefore, I am not in a position to that amount because there is no basis.
All right. Then the authority, before the authority, you participated.
My lord. My lord.
What was your contention on merits with regard to possession?
My lord, my lord, I will refer the document. Prior to that, without going through the document, my lord, in the year of, my lord, the lease was granted to me in the year of 1966. I had been paying the rent all along. Subsequently, rent has been enhanced from 50% to 100%. I raised objection, saying that you cannot do that because the discussions has been made, the amount would be reduced amount. They did not, my lord, accept the same. Therefore, my company taken a board resolution saying that we are going to surrender. There is no other alternative but to surrender. There is a provision in the lease deed saying that if any of the parties intend to terminate the lease, in that event 15 days notice is required to be given. In the year of 1883, 14th of July 1883, we communicated our board resolution saying that we are not interested to in possession and we are surrendering and you terminate the lease. Thereafter, my lord, that has been communicated in the correct address to the authority. Since then, my lord, there are successive communications. They are demanding the amount. I paid the amount of 20,000 and odd figures. Their demand was higher. Subsequently, rest of the amount was there. Then I made certain payments and I told that the subsequent payment would be made accordingly month by month. This is the situation. In the year of 1994, they initiated a proceeding saying that I am in possession and therefore, my lord, I have been unauthorized possession since they have given the notice under section 4 and under section 4 the lease has been terminated and therefore I am in unauthorized occupation. That, my lord,
but then there is some communication where you agreed to pay 8,000 per month against arrears till the total dues are paid. You
no,
paid 20.
only, my lord, there is a, my lord, the document of 1987 where I have categorically stated that I will pay the rest of the amount month by month and I will give a lump sum amount because 20,000 I have paid.
Yes.
Only on the basis of which they have stated so. Because I am not in a...
Where is the proof document to show that your surrender was accepted? It can't be unilateral.
Miller, I am coming. This is the subject matter to be considered by the estate officer. My case, which I have intended to made out before your lordship is this. When the successive notice was given to me, it appears that I did not appear. So behind my back, they conducted an inquiry. Kindly have a, my lords, kindly have a look at the document, the order dated page 95. This is not the second volume. Sorry, first volume. Will kindly take trouble to have a look at page 94 once. The order number 8, dated 15th of June 1999. No one appears on behalf of the OP and the third call and the peruse the papers on the record and the remarks of the postal department is left and the service returned. Department is directed to arrange the publication of the notice inviting all the concerned to appear before me for hearing etc. on the future date. Notice is required to be published in the Delhi Anandabazar such and such at least of the 7 days on the date of the hearing etc. All the concerned are directed to act accordingly. Kindly take me note order number 9, dated 15th of December 2003. The record is put up in the being mentioned by the QOPT. It is seen that the order for the publication of the notice, in the newspaper was given, but the same appears to have not been complied with. It is also observed that the order in this effect was not communicated to the Port Trust. The applicant herein on the consideration of the record, I find that the remark of the postal department on the service return as left in the recorded address of the OP was strong presumption that the law such and such, the good service such and such. As the measure abandon caution regarding the functioning of the OP into the public premises, then mirror. I hereby direct the Arun Kumar Banerjee, Junior such and such officer, Kolkata Port Trust, to submit an independent report regarding the occupation of the OP or any other reasons into the public premises in question by the 20th of January 2004, such report regarding the occupation indicating therein detail such and such. So, my lord, inquiry was conducted. Kindly see the next page.
Yes, he says that no hoarding was there. But
No, last 2 lines is very important.
Logs are remaining.
So that is adjacent plot below occupation. They are keeping the below the logs and then. No existence of the Messrs. Urban Judge such and such was found. The inspection was carried out in presence of the such and such. In a subsequent order,
we'll come to page 100. After recording everything, the estate officer called for the records in connection with the surrender of possession. Where are those records? Surrender has to be mutual. Surrendered and accepted. It can't be unilateral.
Kindly appreciate.
Suppose you just say, I am going out and ask some fellow to enter.
My point is not that. This is absolutely correct. This is the law, the law of the land. But the fact remains, the estate officer, while passing the order, ought to have considered this aspect. Because
where is the estate officer's final order?
Yes.
Which
at page below, 144. They never, my lord, they dealt with this issue of, my lord, I am not in possession. This is 144, my lord.
Page 145 middle. On examination, it is
No,
stated
then
here,
146.
there is
146
no
last
such
question.
certificate with regard to taking or possession in respect of the public premises in question by port authorities from the opposite party. Chattopadhyay also identifies a letter so and so, so and so.
My lord, the inquiry you conducted, the report has been given. This reflection is not there. So my finding is this: the estate officer ought to have considered the inquiry.
What is the period within which you have to challenge this order before the appellate authority?
The under section 9, my lord, 12 days from the date 12
And
days.
how many days he can condone?
That is not there.
That is
not
You-
there is a
So
provision.
therefore, you file an application for condonation of delay and say that notice was sent to a wrong address. I have surrendered possession as 30 years back, and I have made it clear in my communication which I sent in the year 1994.
83.
83, 94, you have reiterated.
Yes,
You
yes,
see
yes,
the
yes.
last communication,
9.
page number 99. You said 10 years back you issued summons. I have said I am no longer there. Once again, you are saying I am no longer there. You establish that. And we will ask him to consider that.
Only difficulty is this, my lord. Kindly have a look at.
It's a question of fact, sir. You will produce some document. He will produce some document. You will file an affidavit.
No, I will not invite your lordships to, my lord, adjudicate. Only, my lord, I will invite your lordship, my lord. The estate officer passed an order.
It is a specialized enactment. Let it. Your case is that you are not aware of the order. It was not communicated. But you need to establish that.
So, my lord,
they will call for the original file, to which address it was communicated, where it was communicated, and all sorts of things they will do. And you take advantage of the junior officer's inspection report.
What accommodation I am seeking before your lordship is this, my lord. Since the initial demand on the basis of which proceeding was started in the year of 1994, 1,82,000. If the interest would be given also, in that would not reach to 50 lakhs or 55 lakhs. They have incorporated a principle which has been subsequently promulgated that the demand would be multiplied. So, my lord, the only difficulty is this: I am not in a position, I am not in occupation. So, my lord, it would be very, my lord, the pathetic saga of the petitioner and the appellant before your lordship is this: he has to deposit of the amount demanded, which does not have any basis. And, my lord, the proceeding has been, my lord, kept pending for there only.
But then paper publication has been filed.
No, paper value has not been made. I have shown to your lordship, my lord. Kindly have.
Documents annexed in the writ petition, it appears paper publication of the proceeding was made.
No. This is erroneous recording of the, my lord, the honorable judge. Erroneous recording. I have shown to your lordship, my lord. Kindly have a look at page, my lord, the 90, page, my lord, 95. Page 95, my lord. This is erroneous. No, page, my lord, this 60. Sorry, page 95, my lord. They have in the order, they have categorically stated.
Yes.
The publication of the newspaper was given, but it appears that has not been complied with. So paper publication was not there. This is the erroneous finding of the honorable single judge.
Is it correct?
Paper publication was done. My lord, may I just place
you keep the reply first.
three pages before your lordship. Kindly come to the eviction order, page 143. That was not shown before your lordship. Lordship will find she further states, it's about, my lord, 12-14 lines down the order. She further states, has your lordship got that 143?
143,
Yeah.
order dated 21st March 2006.
She further states that it is the procedure and practice followed since long at the time of handing over possession to anybody by the port authority, an execution of certificate possession is necessary, and the same time execution of a certificate like nature is absolutely necessary for taking over possession by port authority from any tenant occupier of the port property. Now, while a lordship see there is a complete decision at page 146, lordship takes the finding of the judge. I find that, Lordship's 3 lines, if your Lordship 3 lines leave,
Fifth
I
line
find
from the
that
top. Fifth line from the top.
fifth line from, I'm sorry, madam. I find that OP has failed to adduce any evidence or bear any witness in support his contention regarding surrender of possession of the public premises in question. The question raised on behalf of the port authority on the basis of OP's letter to land manager with the prayer containing inter alia to deposit current month's rent. I am of the view that this letter is an independent, very strong piece of document in support of KOPT's contention regarding non-surrendering of land in question by OP. As such, OP cannot deny the liability of paying charges for occupation of damages up to handing over possession. Admittedly, possession came into occupation as a
There is this
monthly.
letter of 24th of December 1987.
Yes, that was shown on last occasion. I am just showing 19. Letter that later they say
page 78 এর পরে হবে, page 78 onwards.
Page
just a minute, 78.
Page 81. No. Page 79.
79.
Well,
oh, sorry, sir. That is, no, page 80.
No, page 79, my lord.
Page 79 is the notice, sir, by the land manager.
Yes.
Page 80 is your letter.
Yes.
To allow us to deposit the current monthly rent every month, allow us to deposit amount just as less equal to 1 month rent every month against arrears, exempt on paying interest. This is an admission.
Kindly
now, I have just I want to elaborate on a point of law. It's a it's a well settled proposition of law. I will show the law training judgment, also the present judgment of this honorable court. So, appeal court, deed court cannot be turned into an appeal court, and decision may be bad. The question is, the decision making process, whether that follows or not. One judgment.
Yes, my point is exactly on that same
paragraphs. 2 paragraphs.
This is an afterthought.
Kindly have a look.
This is see the
2 paragraphs.
Letter which was given by the associate, the writ petitioner, which is in page 80, is fatal.
Miller, kindly take trouble to have a look at page 83.
If you have surrendered possession, there should be a certificate of handing over.
Correct. This is the absolute principle which is required to be followed. This is a settled law. I am not on. I am on the estate officer is an quasi-judicial authority. While he is exercising his power, he has conducted an inquiry. This report of the inquiry ought to have been considered by the estate officer good, bad, indifferent. Yes. Since, my lord, this is in my favor, that has not been considered.
No, you can't expect him to write a judgment. But the reasons have been given.
No, reason is there, below the inquiry whether that has been done, that has not been taken care of. That has not been considered by him.
And the learned judge also has rightly appreciated the finding.
Yes, for which alternative remedy is there. Well, may I just, I cannot resist my temper to 2 paragraphs. Only the thing. Kindly take the last page. The finding of a King's Bench judgment. Lordship will find, it's the 3rd paragraph. It is plain. Last page, and the last page. It's plain that certiorari will not be issued as the cloak of an appeal in disguise. It does not lie in the order to bring up an order or decision for hearing of the issue raised in the proceeding. It exists to correct error of law which revealed on the face of the order of decision irregularity, absence of excess of jurisdiction were shown. The control is exercised by removing an order division and then quashing it. So this is the now, my lord, division bench of our court also followed it. 1 paragraph, my lord, I am relying. Ekta copy. Okay, ekta copy. Well, kindly have a look at paragraph 31.
Lord, I have concluded not my
paragraph 31. Well, kindly sees.
Let him argue then.
Paragraph 31. Lordship will find here also this honorable court also. Well, took the same. Paragraph.
Yes, we have seen.
Paragraph 31.
But how come they, no, that is one aspect.
Yes.
Initial demand was, they say is 1 lakh and something.
No, Miller, kindly take trouble only. Now, I take trouble only one thing. Only one thing. Kindly have a look at page 54. This is the proceeding which has been drawn up on the basis of their, my lord, the application before the estate officer. The total amount was
page 54.
Page 54. Proceeding starts from page 83. Their application starts from 84.
Page 54.
Kindly see the annexures they have given 1,82,583. So initial demand at the time of adjudication was 1,82,583. Then this amount, my lord, kindly see the final order.
No. Where is page 54 is your writ petition?
No, page 54. No, I am
There are
referring.
three page numbers. You are referring volume, which volume?
I am referring, my lord. Sorry. Volume 1. Volume 1, page 83.
82.
83.
Yes.
Kindly see, my lord, this is a notice which was given on the basis of the proceeding which has been drawn up. The proceeding number is 204, dated 1994. Then kindly see that the notice has been served in my address, 5th Jawaharlal Nehru Road, Kolkata, such and such. See, 5th Jawaharlal Nehru Road, Samuel Kumar Mullik or Mukherjee, who has accepted in presence. So they are aware about the fact that I am in position, I am in, my lord, my office is 5 Jawaharlal Nehru Road. Then, my lord, this proceeding started 2004 of 1994, page 84.
But then this is a sequel to the earlier proceedings. As long as the original order of eviction or an order holding you to be an unauthorized occupant, because the finding is there. If you see page 108,
kindly see the prayer, man. Kindly see the prayer at page 86. Page 86, my lord, of that application.
No. See, there is no point in assailing the correctness of this order alone. As long as the findings given at page number 143 to 147 or 148 stands without a challenge, nothing can be done.
Nothing can be done.
That's the problem.
Well,
the original order at page 143 holds you to be, renders a finding that you have not proved surrender of possession. The once that fact has not been assailed, this is a consequence of that proceedings for damage, use and occupation.
My lord, this is the consequential order. Original order is 27th of March 2006. If the 26th of March 2006 is in my favor, in that event, subsequent proceeding would not be there. So I have challenged the original order on the basis of which the right has already been crystallized. The order dated 27th of March 2006, where I have been told that I am in unauthorized occupation.
Yes.
So subsequently proceeding has been drawn. So when I came to know that, my lord, the order dated 27th of March 2006 has already been passed in the year of 2024, immediately I approached before this court, before this honorable court, saying that my right to appeal is not there, since, my lord, the substantial period has already gone, and I am not in a position to also prefer an appeal only because that no document has been given to me. So therefore, my lord, it has been submitted before the honorable single bench saying those. So in other aspect also, the order passed by the honorable single bench is not correct, because on the merit of the matter it has been stated this is not perverse, this is not violative of the natural justice. In other hand, they are saying that there is an alternative remedy. Two things cannot go side by side.
No, there is an alternative remedy exist. Well, I tell you, Lordship, what is the reason?
I would be remediless.
Well, I tell you,
allow me to complete and thereafter you.
No, 22nd of August 1990 was the order of ejectment has been passed. Whether you challenge that order?
My lord, which order?
22nd of August 1990.
No, 1990 no order was passed.
Yes.
Page?
Page 144.
Just a minute. Page 144.
Third line from the top.
Page 144.
Or you read from the top. The matter is taken up today for final disposal.
Yes. The matter is taken up for today for the final disposal in case of the Kolkata Port Trust. The applicant here in the non-payment of the rental dues in respect of the property in question has been given rise to cause of action in the OP, and the ejectment was served in the OP number such and such, dated atu, for the delivering possession of the QOPT.
So therefore, then the estate officer goes on to examine whether your contention that you have surrendered possession is correct or not, and renders a finding that there is no document. As long as the ejectment order remains intact, all these consequential defense you can never raise.
Milord, only the thing is this, which is there over there, Milord. Kindly appreciate a situation that suppose 27th of March 2010 order has been communicated to me. In that event, I ought not to come before the Honorable High Court.
No, even then you will be out of time because you have not challenged.
No, I am not challenging the
ejectment order. You need to challenge.
No,
See, an ejectment can be order can be passed only in respect of a person who's in possession. Your case itself is, sir, I am not there in possession.
Correct.
So that you should have questioned that ejectment order dated 22nd August 1990.
The proceeding has been drawn on the basis of the notice which has been given under Section 4 determining the tenancy. So this is, Milord, Milord, the original. Milord, I should not be remediless because Milord, the otherwise only thing is this, I am not in possession. Since
that you have not established.
That there is a conclusive finding. Well, Lordship's judgment, this judgment and paragraph 21. Well, in case of eviction order, he has to go. Well, Lordship sees this bench order I am placing. Paragraph 20. Okay, the copy. Paragraph 21, Lordship sees. Same applies to this case. Only one. Now, will I tell you, Lordship, they are not interested about possession. They continued. Well, kindly think, visualize. They participated in the proceeding. There was cross-examination. There was everything.
The original ejectment.
Original ejectment proceeding. Well, that they had no objection. That is, they lost nothing. Now, when the damages proceeding started, then they woke up from the slumber, saying that now the damages from
out of court.
That damages
I will be out of court. They would be able to show single document. The order dated 27th of March 2006 has been communicated immediately after promulgation of the order.
Please come.
Milord, only one thing, Milord. He has already, Milord, relied certain decisions, Milord.
He will not refer to any of the decisions. We will support our reasons.
Milord, may I
conclusion by our own.
Milord, may I submit, Milord? The order which has been passed by the Honorable Single Bench, Milord, there are the erroneous finding. It appears from the face of the record. If your Lordship, Milord, I will be impressed to your Lordship, Milord, only it appears evident from the document itself. Kindly take trouble to once again, Milord, the impugned order, which is at page 163. Page 166.
Yes.
Second paragraph.
Yes.
From the document annexed to the writ petition, it appears that paper publication to the proceeding was made when the petitioner could not be served at least to the last known address.
This, according to you, is wrong.
This is, according to me, is wrong.
Based on the order passed by the estate officer himself, he says that direction was not complied.
My lord. Next, my lord. Page 166. The my lord, I am referring the middle portion. A field inquiry was held. During the field inquiry, it transpires that the No.1 in the present at the site on the local inquiry. It was learned that the warrant such and such was found functioning such and such, huge such and such. No holding of the petitioner such and such, such and such. Then, my lord, page 167. The legality of the such surrender of the such and such was required to be adjudicated by an order dated April 1, 2004. No such order is there. No such order is there. This is an erroneous, my lord, entry. Liberty was given such and such for the erroneous such and such. The kindly see, my lord, last 5 lines from bottom. The representative of the petitioner number 1 failed to adduce any evidence either through the document or the witnesses in support of such surrender. Kindly have a look at page 72, 73, my lord. Volume 1.
Yes.
My lord, the relevant portion, page 74. I am referring fourth line from top. My lord, the fourth paragraph. Under the circumstances and after the matter of the board of the directors of the company, which was held on the 11th of June 1983, it was unanimously decided that since your department, even after the repeated requests and the discussions, has failed to comply with the rules and the regulations to provide us with the calculations and the based on which the outstanding dues were arrived at such and such completely contrary to the rate in the terms of such and such of the actual rent, and the actual rent we are left with no other option but to hand over and the surrender the leasehold property mentioned such and such. Next is important. You are therefore requested to terminate the lease agreement between us and provide us with the exact amount which is due and payable. My lord, kindly take trouble to have a look at the lease agreement, page 68. Leave aside that this is a case of surrender. This is a case of termination of the tenancy. My lord, kindly see page 68, first paragraph, second paragraph. The tenancy will be on the month-to-month basis, terminable by the 15 days notice on either side, expiring with the end of the English calendar month. Assuming that this is not a surrender, but it is a termination of the tenancy, I have given a notice in the year of 8.
All right. This notice was given by the SSC, by the writ petitioner,
My lord.
page 73 on 14 June 1983.
My lord.
But the ejectment order came to be passed on 22nd August 1990, where this issue was considered. That order has attained a finality. Now this is sort of an execution proceedings where they are claiming damages for use and occupation. So that as long as that order remains unassailed, you don't have a case.
So, my lord, may I be permitted? May I be permitted? Because, my lord, so far as the impugned order is concerned, impugned order, my lord, cannot go hot and cold. Saying that my lord, the order is perverse, suffers from violation of the natural justice. In other part of the order, last part of the order, it has been stated that, my lord, I am having alternative remedy, therefore the writ court should not entertain. Two things cannot be done. So this observation will go. I will approach before the appropriate forum for appropriate relief. Whatever good, bad, indifferent, there is no difficulty.
He invited all this observation.
My
single judge was relegating the matter to the.
You took the risk. So
yes.
If you had sensed that the court was not in your favor, you could have taken permission to withdraw the writ petition and file it.
Option was given.
Option was given.
Option was given.
It is incorrect. My lord, this is not there. My lord, it was prior to 3 to 4 days of the prior to puja vacation. All the courts are in hurry. Proposal was given to me that you deposit 50% of the total amount. My client not in a position to pay the 50%.
Not at all. Not at all.
50% of the entire amount.
Not at all.
All right, we'll consider on merits.
Lordship.
This intra-court appeal by the writ petitioner is directed against the order dated.
May I be permitted to, my lord, go to the appropriate forum for.
You please hear the order. Intra-court by the order dated 3rd October 2024 in WPO 854 of 2024. In the said writ petition, the appellant had challenged an order passed by the estate officer, Calcutta Pro Trust, under the provisions of the public premises within bracket eviction of unauthorized occupants, bracket close act 1971, dated March 27th, 2006. To be noted that the writ petition was filed in the year 2024. The learned single bench, after noting the facts, found that the challenge to the order passed by the estate officer dated March 27, 2006 cannot be entertained, apart from other things being a grossly delayed attempt made by the petitioner to challenge such an order after having slipped over their avenues which were available to them. The learned advocate appearing for the appellant would vehemently contend that there are several factual errors committed while dismissing the writ petition, and pointed out that in page 4 of the impugned order, the learned single bench has observed that paper publication of the proceedings was made when the writ petitioner could not be served at the last known address. Referring to the order passed by the estate officer, it is submitted that no such paper publication was made, and the estate officer has recorded in his order dated 15/12/2003 that publication of notice in the newspaper has not been effected, and the direction issued to the said effect has not been complied with. Further, it is submitted that there is other factual error with regard to service of notice on the last known address of the writ petitioner. Apart from that, the learned single bench has also not appreciated the recording, the facts which have been recorded by the inspecting officer of the portrest, who conducted an inspection and has categorically recorded that there is no evidence, there is nothing to indicate that the appellant company was functioning in the premises. Thus, it is submitted that the writ petitioner ought to have been thus the writ petitioner could not be left remediless, and he should be able to pursue the challenge to the order before the writ court. We have heard the learned advocate appearing for the respondent portrest on the above submissions. Before venturing into the reasons assigned by the learned single bench for not entertaining a very belated challenge to the order passed by the estate officer dated March 27, 2006 is acceptable. Apart from that, we hasten to add that the challenge to the said order has to fail on other grounds as well. As could be seen from the order which was impugned in the writ petition dated 27/3/2006, the writ petitioner was put on notice by the portress authorities for non-payment of rental dues in respect of the property in question. This gave a cause of action for initiating proceedings for ejectment. Accordingly, an ejectment order was served on the writ petitioner on 22/8/1990 for delivering possession to the portress. And the portress also held that the writ petitioner is liable to pay rental dues up to September 1990, amounting to rupees 1,82,583.50, and also the damages for unauthorized use and occupation of the property in question up to the date of recovery of possession from the writ petitioner. Thereafter, a show cause notice under Section 4 of the Act was issued to the writ petitioner on 25/3/1994, calling upon them to appear in person or through their authorized representative and produce any evidence in support of their contention. The estate officer has recorded that the writ petitioner all along contested the matter through its advocate, and finally stuck to the contention that the question of handing over of possession to the portress in terms of the eviction notice does not arise at all, as according to them, the public premises was surrendered to the portress long before. The learned advocate for the appellant would strenuously contend that the writ petitioner had addressed the land manager of the portress as early as on 14th June 1993 by way of a notice, and the notice was to terminate the lease agreement between the portress and the writ petitioner, and also calling upon the portress to provide the exact amount that is due and payable in respect of the actual rent outstanding from June 1982 to May 1983, and arrears rent from 25th June 1981 to 31st May 1982, in accordance with the increase in rent at the rate of 50% which has been agreed upon by the writ petitioner and the portress in terms of the amended rules and regulations of the portress. Further, it is submitted by the learned advocate that in the said notice of termination of the lease agreement dated 14 June 1983, the writ petitioner had made it clear that that they had surrendered and or handed over the property to the department, and there's no liability which remains outstanding in respect of the agreement between the petitioner and the department. The petitioner, the appellant writ petitioner is precluded from relying upon the said notice dated 14th June 1983 for more than one reason. It is much after the said notice, proceedings have been initiated for ejectment, which ultimately resulted in an order dated 22/8/1990, by which the appellant writ petitioner was directed to deliver possession of the property to the portress and also made liable to pay the damages for unauthorized use and occupation till the date of recovery of possession from the writ petitioner. Thus, as long as the initial order of ejectment dated 22/8/1990 remains unassailed, the question of the writ petitioner challenging the consequential proceedings, writ petitioner challenging the subsequent proceedings filed by the portress under section 4 of the Act, which is in the nature of a consequential proceedings for recovery of the arrears of rent for unauthorized use and occupation. So far as the estate officer is concerned, in the second round of the proceedings, he has examined the contentions raised by the writ petitioner with regard to as to whether there was surrender of possession or not. After appreciating the stand taken by the writ petitioner, the estate officer has recorded a factual finding that the writ petitioner has failed to produce any evidence or produce any witness in support of their contention regarding surrender of possession of the public premises in question. Thus, the order came to be passed on 27/3/2006, which was belatedly challenged by way of a writ petition in the year 2024. Thus, full stop. Admittedly, the estate officer is not a civil court. Thus, what we are required to examine is whether there is any error in the decision-making process, and it is not for the court to sit as an appellate forum over the decision itself. In our view, the proceedings cannot be faulted for any error in the decision-making process, and we find that the conclusion arrived by the estate officer has been supported by reasons. Thus, apart from the grounds on which the learned single bench has rejected the challenge, the above grounds are also good and sufficient grounds to reject this appeal. Accordingly, the appeal fails. Dismissed.
I'm grateful.
Great. How many days delay? No delay.
Proceed only.
Is there a delay in filing?
No.
Oh, yes.
Only humble prayer, my lord. Item number 20. Can it be on Friday, my lord, instead of tomorrow? Because
let it remain in the list.
My lord, tomorrow I have some difficulty. That's
we will pass over. Not to. We'll say to not today.
I'm grateful, my lord. I convey my deepest condolences, my lord. Item number 15 and 24, I'm going for Vivad Se Vishwas.
Item 15 and
24, my lord.
How many days delay? No, it's an
no delay, sir. I'm going for Vivad Se Vishwas.
So therefore,
Therefore, it can be taken up sometimes in January and or February, my lord, so that the scheme is over.
Which is your case?
Number 22, my lord, I am appearing for the respondent. I don't have a copy of the application. My lord,
Who will appear for the department?
my Somen Bhattacharya, my learned friend.
Where is Bhattacharya?
22, my lord.
22.
But 22 I am appeared. 15
I don't have a copy of the
Why don't you serve copies?
No, I don't know how they have served, let the copy be served and.
You share a soft copy, he will take a printout if he wants.
Millard 15 I am appearing, Millard. He had mentioned, Mr. Surana mentioned
Surana,
15.
he wants an adjournment because they are going at the
Because he
PSVS.
Vishwas.
Item number 11, but the appearing plots, there's defect in the file. Let me go to the list. We have not filed any stay application, but the only date has not.
Go out of the list.
I pray for heartfelt condolence.
Yes, thank you.
Yes.